committee hearing. We'll do roll call. Rod Hall. Vice Chair Bollinger. I did see Erin Longacre earlier. She is not present, but I believe she's in the building. And then Board Member Lear, I believe, is on her way. So we want to welcome everyone out to our law and licensing meeting this morning. Vanessa, do we have any public comment? Okay, thank you. So let's dive into the agenda. And our first action item is the board bylaws 4. And I don't see Deputy Nui, so Director Rasmussen, are you prepared to address that with us today?
I wasn't involved in the last discussions on that, so I don't know what the most recent changes are to present that.
Do you have a copy of it?
I can pull it up.
Okay. While you're doing that, let's go to, if there's no objection from the committee, to action item 1.3, R277-305, school leadership license areas of concentration and programs. And Dr. Height, are you here to present that? Thank you.
Hello, good morning. Malia Hyde, Executive Coordinator of Educator Licensing. This morning we have R277-305, School Leadership License Areas of Concentration and Programs. And we have just a couple of amendments for this rule. Consistent with SB 66, we've updated some language about classified personnel to call them education support professionals, and while we are doing that, we are also aligning some out-of-state licensing requirements to align to our other board rules. Thank you.
Are there any questions from the committee? I'll give the body a few minutes to review the rule. I know we had a full agenda yesterday and then the teacher ceremony last night, so I don't want to rush. Board Member Hall?
So Dr. Hyde, it says this is a category 4. So all these it all falls under category 4, these types of.
Yes. Member Hall, that means that we review 100% of our school professional or our school leaders to make sure that they're appropriately licensed.
Okay.
Yep, and have met these requirements.
Dr. Hyde, I have two questions. Oh, just two questions. On line 105, it talks about some of the requirements being waivable, but no more than 10% for the incoming cohort. Two questions. One, which requirements specifically are we saying are waivable? And then why would we permit that? And then why cap it at 10%?
Sure.
I guess that's 3 questions. I said 2, but.
Yeah, so this provision is for our Utah universities that offer a school leadership licensure program. The requirements are in the previous section, starting with 88. And go through things like they have to have a background check, they have to have a professional educator license, they have to have a recommendation from someone in their LEA showing that they can do it, and then pass an interview exam. What we have seen historically is we know that they're not failing the background check, because in order to get the school leadership license, they still have to pass that, so that's not being waived. What we are seeing is that somebody who does not have an existing license, that requirement would be waived. And where we're seeing it applied most frequently in Utah is for people like seminary teachers or institute directors who have education and are trained teachers, but they don't have a public school teaching license. And so then they go on to obtain the master's degree and obtain that school leadership license. That's where we're seeing it most frequently.
And why 10%?
That has been around for a long time, far before my time. I think that was just at the time what the board's threshold said that makes sense. And we have never seen a university come even close to hitting that.
Okay, that was going to be my fourth question, so thank you, Dr. Height. Vice Chair Bollinger?
Thank you, Chair. Dr. Height, if just for the public to understand a little bit the changes that have been made as far as you were talking about if they're coming from out of state, can you just speak to what that actually means in practice?
Yeah. So, consistent with the 2023 SB 35 license by endorsement, anybody who has a professional level license that comes from another state in any industry with a year of experience is granted a professional license. And then, consistent with our other licensing rules, anybody who has a professional level license in another state gets a Utah license that is equivalent. So if they're a licensed administrator in another state, then we would grant them a similar license. And that's where the language says a NASDAQ stage 2. That's a national standard.
Board Member Lear, I can't tell if you're ready. Okay.
Yes.
Okay, Board Member Lear?
Reading such subtle body language. I was a little bit sarcastic. I'm really conflicted about this, and I've heard from both both sides of concerns, and you and I have talked about it, obviously. But help me understand. Most of the teachers or the teachers' representatives who I talked to said we're okay if this is like closely related. They wrestle with that closely related notion, and I don't think that ended up in here, right? It didn't. I mean, hold that for a second. You can answer these all at once. This is just a lead up. So I don't think it did, but help me understand, and again, for everyone's and the public's kind of knowledge, why did you not go with closely related, and how could this work? And because you're not going to want a junior high English teacher teaching calculus, and I know that's an extreme example, and maybe there is one out there, but how is this going to work that is going to make people feel like we're not just continually diluting the value of a license?
Sure, Chair, if I may. That language is most equivalent, and that language is in both the state law as well as in R277301, the Hallmark licensing rule. And that language has existed for, I think 2 or 3 years already. And so when we apply that policy to licensing, it is equivalent. So if somebody doesn't have a license to be a school principal in another state, they do not get the school leadership license area in the state of Utah. So if they have a license to be, say, a special education director, which some states do offer that license, they would not earn a school leadership license area because it is not equivalent to being a school
So
leader.
repeat that phrase again. Mostly equivalent.
Yeah, it's
Closely equivalent.
yeah, the equivalent.
Okay.
Yeah.
So you think that the rule guarantees enough adequate training, adequate similarity if it's from another state. Because I am also wrestling with the fact that we don't do enough training for administrators, and it's sort of the forgotten group of people. If you want to make more money as a teacher, you become an administrator, and sometimes that works well, and sometimes it doesn't. And the training is I think unfortunately not available or weak. So anyway, just my thoughts on that, and that's my concern, the major concern I have about this. Yep. Thanks, Malia.
So, Dr. Height, I when I reviewed this, I see that it requires the applicant to successfully demonstrate application of knowledge and skills gained through the program and one or more clinical experiences in each of the following competencies. And then there are a dozen or so competencies that an applicant has to demonstrate. As I looked through that list, I really didn't see one that is dedicated solely to the demonstration of proficiency in working with parents. And I see some that touch on that. I see some that maybe fall under a catch-all provision. But my concern is that, State Code 53E-2-201 puts the primary responsibility for the education of their children in the hands of the parents. Do we need to insert a provision that really focuses and tests their competency in that regard?
So
Or do you feel that's covered by a current assessment?
Yeah, so two items. One is that in line 68, one of those competencies is communicating effectively with parents specifically. And then it is attended to in that way. The other thing to be aware of is that we're currently in process of looking at our leadership standards and updating those. They haven't been updated since I think 2010 or 2015. And so that will certainly be part of the new standards that we hope to get to the board next year.
So, Dr. Hyde, I did see line 68 before. If I were to look at the competencies specifically, because 68 says communicating effectively with parents, community groups, staff, and students.
Sure.
And my concern is that we lump all that into the umbrella of effective communication. But I think there's a difference, right, in how we communicate with each one of those entities or individuals. So that would be my I'm not even going to say it's a concern, but my thought. And
Feedback.
so, yeah, feedback. So maybe between now and when this matter comes before the full board, I'll be reaching out and talking about how we can better emphasize that particular competency.
Yeah, wonderful. We appreciate the feedback.
Thank you. Vice Chair Bollinger?
Thank you, Chair. Dr. Height, if I may, Chair, direct a question to Dr. Height. Just for clarity for the public, as when we talk about a license, an administrative license, can you help us understand the requirement then at an LEA level? Are all LEA principals required to have a leadership license, superintendents? Can you speak to the different levels?
Yes, happy to, Chair, or through the chair. In R277309, which outlines the appropriate licensing for individuals in LEA, anybody who's serving as a school principal or assistant principal is required to have a license as the school leadership license area. There is a provision in law that exempts charter school directors from having a license. Anybody else who's serving in leadership at an LEA is not required to have the school leadership license area, but is required to have the license area that the school or the LEA determines. So if somebody's serving as a superintendent, then whatever the board of that LEA determines is required, then that is what is required.
Any other questions? Okay, with that, if anyone is prepared to make a motion, we'll entertain that.
I'm happy to make a motion, Chair. I'd like to make a motion that the committee approve R277-305, school leadership license area of concentration and programs, draft 1 on first reading and forward to the board for approval on second and final reading.
Thank you, Vice Chair Bollinger. The motion before the committee is that the committee approve R277-305, school leadership license areas of concentration and programs, draft 1 on first reading and forward to the board for approval on second and final reading. All those in favor?
Aye.
Aye. Any opposed? That passes unanimously. Thank you, Dr. Height. Okay, we will circle back now to item 1.2 on the agenda, and that is amendments to board bylaws, Article 4. And just by way of background, this matter came before this committee previously. As part of that consideration, this body decided to have that bylaw reviewed by council for their input. I also want to say that I'm happy to report that there was also an informal working group with the maker of the application, as well as members of this body and others, who discussed the proposed changes, worked through many of them. Those are located in draft 1, which is the original draft. There should be a draft 2 in backup, and that one reflects a number of the changes that were agreed to by the working group, but it is not a motion from that group. This is my application because the working group was unable to really get through all of the issues. So I don't want anyone to conflate that draft 2 is anything but my draft to this matter. Director Rasmussen, would you like to address some of the changes made,
Before he does that, can I ask a question?
please?
Did you see my email late last night to you that had the non-sub changes?
Yes.
So I don't need to make those, or I feel like they're all non-substantive. So should I make them, or do you want, or not?
I think we should put those on the record. I mean, I was fine with them, Board Member Lear, but
Okay.
I
that's fine.
just think, yeah, if we could do that.
I think if you can turn it to Deputy Newey.
Oh, Deputy Newey,
Hi.
good morning.
Apologies for my lateness. Yeah, so on this draft too, a few of the changes that you'll see, I think some of the bigger ones are on lines 19 through 22, where it clarifies some of the language with the freedom of speech, but also improper disclosure requirements as required by law. We added create substantial risk, so adding that substantial to the risk to the board when it comes to actions by different individual board members. We did a lot of capitalizing and adding committee chair and board chair, so you'll see a lot of those throughout. Another substantive change is that it gives the option that if there is a disclosure of a conflict of interest, that there's also an option for the body to vote on the chair's decision, whatever that may be in regards to that conflict of interest. And that is on line 45. And then a few more of the larger changes start on line 69. Took out the language about the official position of the board and clarifying some of the language around what is expected of board members when they speak, when there is a reasonable expectation that they could be speaking on behalf of the board. So before it had said that any time that a board member is speaking in public, they should say that they're not speaking on behalf of the board. But we narrowed that to any time that someone could assume that they are speaking on behalf of the board. And then a few more due process things throughout, probably lines 86 through the end on 105. Adding some provisions that there needs to be a 2/3 vote of the board to follow through with any of those consequences that may follow in board members' action. So those are a lot of changes, but if you have any questions, I'm happy to take them.
I do have one question, Deputy Newey, and that is, because I know there was a lot of discussion about this, and is AAG Beal, is she available as well? So maybe this is better directed to AAG Beal. I know there was a lot of discussion around line 22. Before, the standard was if a board member's actions may cause legal harm to the board, that could be actionable. That was changed to the standard of causes legal harm or create substantial risk. For clarification, when we say causes legal harm or creates substantial risk, it's my understanding that creates substantial risk would be inclusive of legal risk. Is that an appropriate?
Yes.
Oh, sorry. Is that an appropriate reading of lines 22 and 23 from your perspective?
Yes, Chair Carey, sorry for cutting you off there. I agree with you. I think that that change, of may not cause, I was concerned when it just said legal harm of how we would define that, but when you include the substantial risk, I think that's inclusive of, kind of what we had been going for before as well as legal risk. So
And then AAG Bill, do you feel that change in any way diminishes our responsibility to protect the board and by extension the taxpayers of the state? Do you think it's diminished in any way by this change?
I do not think it's diminished, no.
Okay, thank you.
Yes, and Chair Carey, just briefly, I had noted one, I don't know if it's technical, I suppose it's not, but it's a typo, I think, in the line above it, line 21. It currently says, as required by Article 7, subsection 19 of Section 67. And the Article 7 was a reference to confidentiality of executive session under the bylaws. So I think the committee will need to decide if you want to include that. That should just say Article 7, subsection 19C of the bylaws and improper disclosure requirements of Section 67. Or if you want to remove confidentiality of executive session, that Article 7 part just needs to be stricken so that it reads consistently.
Yeah, I'm looking at Deputy Newey. Yep, she's giving the thumbs. I did see that AAG Beal. I did look at those sections, so I'm okay with those changes, but we'll see it in a formal motion, and then I'll just ask you to review it to make sure that the language is reflective of what you shared with the body. Okay, thank you.
Perfect, sounds great.
Questions?
I cannot find the text I sent you last night. Can you send it back to me or?
Actually, it's not my number. You're emailing Pizza Hut or something. So right now there's some, but I wouldn't give you my number so that.
I haven't know. At 11:45 at night, I don't know what time it was. I can't remember. It is the weirdest thing. I can't figure out where it went.
I can do that.
Maybe I'm glad it got to you somehow, but then
Vice Chair Bollinger.
one of them was the one you just discussed. One of them was that conflation of the confidentiality and the provision of that I thought needed to be cleaned up because it's not Article. Well, I guess it is Article 7 of 60. It's not Article 7 of 6716. Actually, it's. I think that's the I think that's the Public Officers and Employees Ethics Act. Actually, 6716. Isn't that right?
Correct,
So
yes.
so we wouldn't want to say Article 7 of that because that doesn't make sense. And maybe it says.
Yes, that's correct.
We want to say something maybe or instead of that of there in the middle. So that was one of my concerns. But I'm completely clueless until I get my text back from Member Carey. Thank you.
Thank you. While you figure that out, just one.
Thank
Just
you.
curious to know on line 69 through 70, the language that's been deleted here. Once the board has voted on an issue, the vote is the official position of the board. If we can just have somebody speak to that change. Is that something that was proposed specifically by you, Chair Carey, or?
Been there a long time.
I'm sorry, could you repeat that?
Yeah. So lines 69 through 70, right up here. I'm just curious as to know, because that's typically been our practice, right? Once the board votes on an issue or a policy coming in or a law that they're, working on in the legislature, that's kind of how we've worked, where we vote on whether we support it or not. And just curious to know why that language has been taken out.
I took it out. I recommended that it be taken out because it just seemed duplicative. When the body votes, that becomes the position of the board. And I didn't think it added anything to the bylaw. because we did also omit that right, but there was another provision. It basically said that we would have to state at the onset that, you know, this is the official position of the board. And we changed that to that a member is speaking on, not speaking on behalf of the board. So it didn't seem to be congruent at that point.
Thank you for that, Chair. And just wondering, is this written then in another place, like in our policy bylaw, where, because that's our practice, but I'm just curious if it's written anywhere else.
I'm going to say no, but I'll defer. I don't believe that it is, unless you're aware of something that, no? Yeah,
No,
I
so
don't
that,
think
then
so.
I guess that's my question is, if it's not in any of our bylaws anymore or any of our rules, then is that still the case, is my concern.
That the vote of the board is the official position of the board?
Mhm.
You know, I'll defer to AAG Beal. I don't think that it's something that needs to be stated. I think it's just a given that when the body votes on something, that becomes the official position of the board. But AAG Beal, if you disagree or have other guidance, please provide it.
Sure. So I looked in the bylaws just briefly. I didn't see it anywhere else. I think for clarity purposes, you know, it's kind of nice to have it in there, even if it's not necessarily in the communications portion. But yeah, I think it is also known that what we vote on is the official position of the board. But I like having it outlined in there from a legal perspective. I think the guardrails there make it a little easier. But you know, I think if you decide to remove it, that doesn't mean that it's not true.
So I don't like including superfluous language, and especially it doesn't seem to fit in this particular bylaw. Would there be a more appropriate bylaw for us to include that language in if the board continues to keep it out of this particular bylaw?
Sure. I think it could go, I'm scrolling back up right now. I apologize. Either under definitions, or I think it could go under maybe board meetings under Article 7. I think it would fit fine in either one of those places.
That's interesting. I didn't think of it including it in the definitions, but then that would apply across all the rules then. Okay,
Yeah.
thank you. Vice
No
Chair
problem.
Bollinger, did that answer your question? Okay. Board Member Lear?
I still cannot find that text, so. Did you send it to my email?
Maybe you gave me a Pizza Hut number.
Yeah,
I
I-
just, yeah,
Did you send-
you had emailed it to me, so I just
Oh, emailed
emailed
it
you
back
back
to
and
you
said, here
on
you
my-
go. Yes.
Was it on my board email? Yes. Is that how I sent it? I'm sorry, this is, it, let me just say this in the interest of the board's time and because it's my own late night problem. I will just give those to Deputy Newey. I'll give those concerns to Deputy Newey. There's nothing except capital letters and, oh, there, I finally got it. And I'll just give those to her, and I don't think that, if she thinks that anything is substantive or questionable, then she can either suggest we bring it back to committee or run it by you. So if that's okay with the rest of the group. Is that okay?
I have no objection to that.
Okay.
And again, this will appear before the full body of the board
will.
for a vote at
Thank
that
you. It
time.
was just my own, obsessive grammarizing, so I will just assume that that works okay. Thank you.
And so to be sure then, and just to confirm then, what we're voting on is the language as currently reflected in Bylaw 4. There are some punctuation and grammar that Board Member Lear will provide to Deputy Newey. Those will be incorporated, provided to this body when that's done for review. If any of us have an objection, please let me know. We can either have that matter reconsidered by this committee or advance it to the full board for their review and vote.
Are you ready for an emotion? Is that what you're?
I saw your light on, so I wasn't sure if you.
No, I'm so sorry. This has not been the best morning ever. I'll be happy to make the motion.
If there's no other questions, yep. We're ready for a motion then. Oh,
Okay.
wait, Deputy Nui?
Make that change that AAG bill suggested.
In,
The reference to the
Oh, yes.
code.
oh, so she just put an and in there instead. And Board of Bylaws. Do we need to make that as an amendment first? Do you want that as an amendment first? I move that the committee amend line 21 to read as Article 7, parentheses 9, parentheses C of the board bylaws and section 67-16-4.
Okay, the motion before the committee is that the committee amend draft 2, line 21 to read as Article 7, paren 19, paren C of the board bylaws and section 67-16-F. All those in favor?
Aye.
Aye. Any opposed?
Can we have AAG bill?
Yeah, I think we actually said AAG Bill was going to review. Did we show the language to her, Deputy Nui? Oh. AAG Bill, did you have I'm sorry, I said we would give you a chance to review it and I didn't. Does that comport with the guidance you provided?
Yes, I think so. I didn't know if you guys want to clarify at all. The improper disclosure requirements tie to section 67 and then confidentiality ties to Article 7. So I don't know if it makes it just a little bit cleaner if we say the confidentiality provisions of Article 7 and then the sorry, I'm going back and forth between two screens here. The improper disclosure requirements of 6716 and just tie them each to their titles properly. I think that's perfect. I think that just makes it a little cleaner.
Okay. Christina, is that what you were pointing out? Thank you. Please, thank you. And maybe I misheard, but I believe you said Article 4. Did you mean Article 7?
I said Article 4, this is originally what the draft is up, and then Article 7 is the one that is in the bylaw.
Understood. So the motion before the committee is that the committee amend Article 4, Draft 2, line 21 to read as the confidentiality portions of Article 7, paren 19, paren C of the board bylaws and the improper disclosure requirements of section 67-16-4. All those in favor? Aye. Any opposed? That motion carries unanimously. Thank you.
Chair, may I ask a follow-up question about the bylaw, the definition piece?
Sure.
So if we were to take this one piece that you feel doesn't fit here, and I can understand why, what would be our steps to get that into the definition?
I mean, I would generally ask a member of leadership how that would work, but I would suggest that you can put something on the agenda with 2 other board members, and that's how I would typically proceed. Okay, the next item on the agenda is item
You
one.
didn't vote on the actual
Oh.
bylaw change.
Thank you, Director Rasmussen. We're ready for a motion.
I'll make that motion. I move that the committee approve the board bylaws Article 4, Member Ethics, Draft 2, as amended, and forward to the board for approval.
Okay, the motion before the committee is that the committee approve the board bylaws Article 4, Member Ethics, Draft 2, as amended and forward to the board for approval. All those in favor? Aye. Any opposed? That motion passes unanimously. Thank you. So let's proceed to action item 1.4, R277-731, Catalyst Center Grant Program Policy. This is a new rule. And Director Newey, Deputy Newey.
Thank you, Chair. So this draft came out of a bill that was passed by Speaker Schultz during the last legislative session. If you recall, so the Catalyst Center is an actual center out of Davis District, and this grant program is meant to allow other districts to expand their own programs that are similar or to create new ones. And so this rule specifically governs the applications for the grant, what that application process looks like, the types of things that we as the superintendent and staff look for in granting those grants to LEAs, and then what is required of LEAs once they receive a grant. And so it doesn't provide provisions generally for these types of programs. There's a lot of other rules that do that, but this is specifically for the grant program. Because all the language is new, it's hard to choose what to point out and to highlight. But I will, if you scroll down, section, I'm just going to do with definitions really quickly. So one thing I'll point out is on line 25, this does allow LEAs who are smaller, so that could be charter schools or small districts, to come together in a consortium to apply for the grant. And there are aspects of that throughout the rule of what that would need to look like. We'll also point out that 23 and 24 point to the definition in code of what a Catalyst Center looks like, or a profession-based learning center. We are looking at potentially changing the name of this. We are kind of waiting on a lot of stakeholder feedback on what we would name this program. But generally, it will be what is defined in code in 53E3507.1. So that's where you can go to see what exactly one of these centers should look like and what it should include. If you go down to section 3, these are the grant requirements. So what is required of an LEA before and during the application process. There's a lot of requirements in this grant program, including the plan and a timeline. These grants can go out in or can be provided for a 1 year. It can be provided for 3 years. And so it's a very flexible grant. This is also one of the few grants that allow for capital projects, so buildings and things like that. And so there are some additional requirements because it does allow for capital expenditures. You'll see that on lines 43 and 44 that there needs to be some substantial information about what those capital expenditures will look like. If you go down to section 4, this is the superintendent responsibilities and how we prioritize the awards. So we're looking for those things that are listed on line 75, I think down to line 87. It goes all the way down. And this grant is entirely dependent on the funding given by the legislature. So there's a couple of caveats, I guess you could say, in some of these lines that say dependent on funding, we will provide these kinds of things as superintendent. Also on 86, grants can be distributed through smaller planning grants. So they can kind of be large grants. They can also be small. The time is flexible. So these are really, really exciting grants. 5 is the program requirements. So once you have a program in place, what does it need to include in order to be eligible for these kinds of grants moving forward? And then section 6 is, I believe, the compliance. If you go down the oversight, monitoring, and reports. And so we will get an annual report from every LEA that has applied for and received these grants that include all of the data that we need to make sure that taxpayer money is being spent well, and to also see the exciting outcomes that we hope will come from this program. And I think those are all the big highlights. If there's any questions, happy to go through them. We also have Stephanie Patton here, who is leading this program and this effort, and we're happy to answer questions.
So, Deputy Newey, on line 25, the consortium means two or more LEAs located within the same CTE geographic planning region. And when you described that, you said if they're smaller. But I don't see any prohibition or requirement for size. So could two larger?
Yeah, you're right. I misspoke. It doesn't depend on size. It's just if they get together and do it together, then they're allowed to apply as a consortium.
Okay, you're allowed one misspeak every 5 years.
Thank you. I
So,
appreciate that.
So, but the code doesn't require a size requirement. It can be any LEAs. Okay, and then I have another question on lines 84 and 85. This is under superintendent responsibilities and award prioritization. And it says provides for a large number of students to participate in Catalyst Center programs without limiting participation to students based on socioeconomic challenges. And this can go to you or to Specialist Patton, but could you walk me through what that language is intended to convey?
Sure thing. So that language comes out of the bill. I'm trying to look for the piece of code right now. So online, if you're looking at the bill, 167 of the bill says exactly that, providing for a large number of students to participate in Catalyst Center programs without limiting participation to students based on socioeconomic challenges. So we have brought that over here. We did get some feedback from superintendents that they were curious. They don't necessarily ask for it, but they were curious about whether there would be a definition for large. So that is something that we could consider. But yes, that's where it comes from and what we're trying to portray.
Okay, thank you. Any other questions from members of the committee? Vice Chair Bollinger and then, Vice Chair Bollinger.
Thank you, Chair. Question about going back to the consortium. If a school only has the 9th grade, are they able to participate in a consortium?
Director Stephanie Patton, Director of the Catalyst Center Grant Program. There's nothing that would preclude that. Ninth grade would still be considered high school, so they could do a Catalyst Center Grant Program.
Board Member Hall?
If you don't mind, Chair, Director Patton, a CTE pathway completer, what's a CTE pathway completer?
Someone this is not my area of expertise, but someone who completes a defined pathway.
So a school?
No, an individual.
An individual. Okay,
Yeah, an
so
individual.
what allows a school to be to kind of create that pathway for students? Like I'm thinking of a charter school specifically. Some of these programs and the grants don't apply to those charter schools. What would allow those grants to apply, and what would disqualify them?
So actually, there's nothing that would keep a charter school from applying for the Catalyst Center Grant Program.
I'm just thinking specifically of a charter school in my area that doesn't have access to some of these grants because they're not attached to a local high school. But this particular school is a funnel for this high school. Like most of the kids that leave this charter school go to the local high school, but they don't qualify for some of these grants because they're not in the pathway, I guess. But they offer some of these classes that would be offered that would connect to high schools where the kids can carry on and continue that pathway. So I didn't know what would qualify a school like that or disqualify a school like that.
Yeah, there's nothing, that's a great question, but there's nothing in this board rule or in the code that I know of that would keep a charter school from applying for this grant. And it does not reference specifically CTE completer for this specific grant. There might be other ramifications in other programs,
Sure.
but not for this specific one.
Okay. Thank you.
So-
Dr. Height, did you have something along those lines too?
They would just have, so a CTE pathway is a set of courses.
Okay.
So like health science, information technology, construction. So if they complete those courses and obtain their professional level certificate in that area, then that's completing a pathway. So in order to qualify for those funds, a charter would have to offer all of the courses that lead to a certificate for a pathway to be completed.
Okay. All right. Thank you.
So Specialist Patton, I have a question. Here it says under R277731-4, line 78, that the Catalyst Center curriculum must align with the First Credential program. And it's my understanding that the First Credential program is maintained and directed by USBE. Is that correct?
Yes, in conjunction with the Utah System of Higher Education. And you'll see it if you go back up to line 75. This is just indicating prioritization. So you'll get greater weight in the review of the application if you're aligning with the First Credential.
So a Catalyst Center may not necessarily have to have curriculum that aligns with the First Credential program?
It could be possible that you could be funded without aligning.
Right, setting aside the funding, does a Catalyst Center have to align with the First Credential program? I don't know the answer. If I'll open it up to...
This board rule is specifically governing, right, the funding, those who are funded.
Understood.
So another piece of context, the First Credential program is still in its infancy. It is being developed, and there have been Catalyst Centers that have been in existence for some time. So they have, by default, existed without aligning to First Credential. That will have to happen if they want to align. They do not have to. That is not part of the law as of right now, but encouraged moving forward.
So thank you, Deputy Newey, and that brings up a concern that I was speaking with Dr. Height about, which is, and I just want to make sure that this is, that my understanding is correct, and this may be better directed to Dr. Height, but the curriculum being offered at Catalyst Centers, does USBE see or approve that curriculum when it is provided to K through 12 public school students? Specialist Patton?
Will you repeat that?
So the Catalyst Center is providing curriculum, it's teaching something. When it teaches that information or material to a K through 12 public school student, does USBE have any role in the oversight of that curriculum?
Yeah, a Catalyst Center would still be under any applicable board rules and processes that any other public school would be under. So, and according to the funding that specific Catalyst Center is using, then they're beholden to the same board rules and policies that would be in place.
So if content would be inappropriate to show in a public high school, it would be inappropriate to use or show in a Catalyst Center. Is that correct?
Yes.
Okay. And let's talk about the teachers in a Catalyst Center. If it's my understanding that the law says that they do not have to be a licensed educator. Is that understanding correct?
That is true. That specifically for the Catalyst Center grant program, there is an allowance that's cut out for that, according to the code.
And it's my understanding they're doing that because they want to appeal to maybe perhaps people in the trades, right, that didn't go and get a teaching license but are qualified to teach welding or HVAC. That's my understanding of one of the reasons why. So when an instructor is selected to teach in a Catalyst Center, who oversees that process? Who is the one who has to sign off and say, this individual is able to teach this class in this Catalyst Center?
Yeah, LEAs would still be going through a typical process of hiring, including background checks, et cetera, making sure that LEAs have plenty of checks and balances to ensure that any individual who is working in a school is appropriately vetted and a good choice, right?
Okay.
Minimizing the liability of those who are interacting with school children. Those same checks and balances would still be in place for a Catalyst Center.
Would the individual selected by the local LEA to teach in a Catalyst Center still be subject to R277-322, our employee standards?
Yes.
So these individuals would be considered employees of the local LEA?
Yes.
And that's whether they would teach full-time or part-time or under contract? And I see Director Nielsen next to you. He's nodding his head in the affirmative. So can I direct that question to you, Director Nielsen? Thank you. That may not be hooked up.
Oh, here you can just move these now, I thought.
Yeah, Darren Nielsen, Assistant Superintendent, Student Learning for the State Board of Education. That's correct. Board Member Carey, an employee for an LEA, whether they're on a contract status or part-time or full-time status, are subject to all of the requirements that are placed from this board down to them as far as employees for public education.
Thank you. Any other questions from the committee? Vice Chair Bollinger?
Thank you, Chair. I do have a few questions. One of the questions I have, my understanding is this is going to be a competitive grant. Is that correct? Not everybody is gonna get it because of limited funding?
That is correct. Yeah, that's why there's that provision about who will be prioritized.
And is there a dollar amount that's going to be a maximum amount allowed per applicant? Has that been defined, or will that be defined?
I do not believe so. Mm-mm.
Okay, and then on line 79, one of the priorities is that they demonstrate the ability to sustain the Catalyst Center after the grant period. So when I read that, and especially since this can be spent for capital, my understanding is this is really to help start up these programs, but not necessarily ongoing. So if a school needed these funds to continue it, they would be less likely to be granted this. Am I reading that correctly?
That's correct. So the vision is that there are lots of LEAs perhaps that want to start one of these, but there are a lot, if you consider especially like welding programs, right? That's a lot of equipment that you need one time, but is very expensive the first time around. So it gives them that startup funds to get it going. It could also be to expand. And so if they have a small program now, they could expand it and do those kinds of projects.
Could we go to lines 125 and 126? And they read, Catalyst Centers may be co-located on the campus of an institution of higher education with an agreement between the LEA and the institution of higher education. Who would fund the construction of that building, that center, if it's located on the campus of an institution of higher education? Specialist Patton?
It could possibly be funded by this Catalyst Center grant program. It could be funded through many other sources.
And once that Catalyst Center is, because this is the Catalyst Center is being built by an agreement with the LEA and a USHE school, because the LEA involvement, would it be subject to the building code and security requirements that an LEA would typically be subject to if they built any other building?
Yes, yes. These funds would still programs or any capital expenditures done through this grant program would be accountable to the same board rules and policies that are in place. Yes.
And how do we know that?
You mean how would we monitor that?
Well, how do we know that they're subject to it?
There's not, because there's not some clause in here that says, well, if you do it through the Catalyst Center grant program, now you don't have to follow any of the other board rules and policies. So any of the accountability pieces that are in place with other board rules and policies and procedures would still be in place for these funds. The only exception, right, is that allowance for teachers that may not, instructors that may not be certified.
Well, let's go back to that. So if a teacher, let's call them an instructor, if an instructor is selected to teach in the Catalyst Center and they act inappropriately, it's your understanding that the LEA would be able to terminate that contract with that particular instructor?
Yeah, through the same processes that would happen, not UPAC, right, because they're not certified, but through similar processes as established in their human resource policies, they would be able to.
And regardless of the infraction that results in their termination, would this body have any way of knowing that that individual instructor had been terminated for cause?
We do not collect that information as that's individual LEA, employment law
So,
situation.
no.
No.
We wouldn't know.
If it was, did we assume that person's not licensed?
That's the assumption.
Yeah, that's the build off of
I'm sure you'll have some teachers that are licensed and some that are not. So it would depend on the license status of the teacher.
Let's
Correct.
focus on the non-licensed, because the licensed, we do track those. So you have an individual who's non-licensed, they're terminated for cause, they can no longer teach in that particular Catalyst Center or for that LEA. They decide to go 20 miles up the road, apply at a different LEA, apply at a different Catalyst Center. What safeguards do we have to ensure that the subsequent employer is aware of the misconduct that occurred up the street for a different LEA?
So that question, if I may, Chair, is a little outside of the scope of this particular rule and would fall under other kinds of rules, right? And other kinds of laws, such as employment law. We've talked about this with 322, right? And other kinds of things like that. For the scope of the grant, for purposes of the grant, there would be no way, and that would not be attached to the funding of the overall program. So,
And I appreciate that. Our role is general control and supervision.
Mhm.
And I don't want to be in a position where we're encouraging students to attend a Catalyst Center, a field trip, any type of school activity where we are unable to do our due diligence. And so here, if they're not an employee, we really don't have a system to track or monitor earlier improper behavior as we do if they were a licensed educator. Is that correct?
that is correct.
Okay. Could an LEA require a license for them to teach for them in a Catalyst Center?
Yes.
Okay. And what kind of license could they require the applicant to have?
They could require them to go through the same alternative routes that the Apple program or LEA specific licenses that are available to individuals who don't have licenses.
Okay. Thank you. Any other questions?
Yeah.
Thank you, Board Member Lear.
But now I have to remember it. Oh, as I was reading this, the first credential that's capitalized program caught my attention. And I've not heard of that. And I just was asking Deputy Newey about that. And she said that the development of that rule is in process right now. But I think for better understanding in this rule, it would be good to add a definition of first credential program. But as she informed me, that definition won't be ready really until between now and the board meeting, next board meeting. So I would, if it's not too open-ended, I'd like to move that we make an amendment and move that we add a definition of first credential program to this rule before the rule comes to the state board.
I'm not opposed to it. I mean, I guess the better place would be in the actual first credential program rule, but since that is non-existent, you're suggesting we add it here.
Kind of. I'm saying because it's used in this rule, it should be defined in this rule. Even if it's first credential program means the program defined in R277-XYZ.
Yeah, and the motion, yeah, that's, I understand the
Because
logic.
it struck me as something I'd never heard of, so I'm going to assume that it's going to strike others who are maybe interested in these catalyst programs. What does that mean? What does that imply? Can it be useful to me? It gives me a priority. So I think they should and would want to know how to access the information about it. So if I can make that motion, if it's not too open-ended, of course I could make the same motion in the board meeting in October, but that's so long from now, and I'm probably gonna not remember. So I just hoped we could add it now.
Director Nielsen?
Yeah, I'm happy to talk a little bit about the first credential because I have some responsibilities on behalf of the board of co-chairing the first or not co-chairing, but staffing the first credential oversight committee that was established in this last legislative session. That committee, which consists of about 20 individuals from industry, higher ed, workforce services, probably missing a group, Talent Ready Utah and so forth, have the responsibility of preparing the first credential master plan and presenting it to the Education Interim Committee in November. Today, the prime rule, which is a board rule, that was a pilot program established a couple of years ago, will be up for renewal in the Standards Assessment Committee. So you'll hear that rule mentioned next month in the board as well. First credential will replace that. So today we'll recommend to the Standards Assessment Committee they extend that rule until we get through the November Education Interim Committee, and then we can develop, the board can develop a rule for first credential master plan. The two pieces of legislation, the Catalyst Center and first credential, they connect together in some ways, right in those bills. They want these two programs to be related and working together. So Director Patton is helping staff the first credential oversight committee. So I believe there actually is a rule or a definition of the first credential program in the statute that established the first credential.
Uh-huh.
And so I believe we could pull that and have that in the rule by the time this comes before the full board.
That'd be great. I was just going to ask a follow-up question to make sure that we wouldn't have to wait to November until these are both fleshed out, that there is a definition that we could use and be available in the rule by October. So that's great. That's what I heard you saying, and thanks for that background. That's really helpful. So if that's acceptable, then I'll make that motion. Do you want
Please.
me to do
Yes.
that again? Okay. I move that the committee direct staff to add a definition of first credential program prior to R277-731 coming before the full board in October.
The motion before the committee is that the committee directs staff to add a definition of first credential program prior to R277-731 coming before the full board in October. All those in
Sorry, before we vote on this, just
Yeah.
one thought, going back to the discussion about licensure for these teachers that are teaching this, just discussing what possible options we have. I'm just curious from this board or from this committee, if we were to, because we also have 301 on our agenda later, and just curious if there is an appetite for potentially adding an additional licensure. So currently we have our associate license, we have a professional license. So some type of licensure title, whether industry, I don't know the title. I mean, we can work on that, but just curious if that's something you guys might be interested if we were able to do something like that. Not only do they have to do the background check, but addressing Chair Carey's concerns, they would be subject to UPAC. Curious to know if that's something that
Well,
would be of
at least it's not a weighty issue that they're asking us to decide on the fly, right? I mean, let's just create another category of licensure. You have 30 seconds.
And,
Can I
and maybe,
speak to that?
and Chair, if I may, maybe Dr. Height can help us understand what that
Yeah,
could or
sure.
possibly
Let's
might
ha-
look
let's
like.
hear from her.
Dr. Height, please.
Yes, thank you. Malia Hyatt, Executive Coordinator of Educator Licensing. The license types, educator license types, are actually defined by the legislature in State Code 53E-6-201. And we only have 4 defined license types. A professional, associate, LEA specific, and provider specific licenses for our SOEP program. So it would require a change in code to add a different license type, but we could certainly look at adjusting the requirements for those different licenses.
If I may, if that's a follow-up. So originally we had heard that it's not required for them to have a licensure in code. Does it say they don't have to have a professional license? If we were to do something like that, would be in conflict with code?
So yes, Chair, or through the Chair, in HB 447, that was the Catalyst Center bill, they added to 53E-6-204 exemptions from licensure that anyone teaching a CTE course is exempt from licensure if they have industry experience as determined by the LEA. So even if we adjusted the requirements for a license type in 301, then an LEA could employ somebody without meeting those provisions through the state law. But we could certainly work with the legislature on a code change next session.
Please, Member Lear.
First of all, I think we need to go through with that may be in our future, but I think we should go forward with this. So let me say this about that. Secondly, without knowing the capacity of UPAC and the constant concerns and our ongoing requests to the legislature for more funding for that, and our lack of, and our the fact that we haven't received that, I hesitate to add a whole new group that are sort of quasi-trade employees, and some kind of a licensure requirement that then would increase, and I don't know how much that would be. It seems to me if it would apply to these kinds of employees in the Catalyst Center, it would also apply to certain CTE teachers who don't have licenses, who have similar experience. So I'm really reluctant to do that without more study and without more immediate resources. Secondly, I don't think we should immediately underestimate or dismiss the fact that school district employers and charter school employers are required to follow a process to hire people. And they don't want teachers who have troubled pasts or questionable issues in their background. And my experience is out of many hundreds, maybe 100, I can't even remember how many total teachers there are. But out of all those teachers, we see a small fraction of them at the board, and I think that gives us sometimes a strange view of the problems in the teaching profession, given it's such a large group of employers, and we work with a lot of children, obviously, that we care about. So I think that the employment processes are pretty strong in most school districts and charter schools. And I'm personally not immediately wanting to take on another category of licensed individuals. I think if we need to do something, perhaps the board sends a message to LEAs to look more carefully about your employment processes. We don't want to monitor those. And so look at them more carefully. Make sure you're following the law. Make sure you're contacting past employers before you hire somebody, because that information would be in the past employer's file. So that's my concern about going down this path, but it doesn't stop us from approving this now, and shouldn't, I don't believe.
I agree. Vice Chair Bollinger?
Yeah, I agree. I do. I just was curious to see if that's happened, but you bring up some great points and some things we need to consider. So I appreciate that. Thank you.
Any other questions or feedback from the committee? Seeing none, we are ready for a motion.
I'll make,
Did we vote? We didn't vote on my amendment yet, did we?
I don't believe so.
So
No.
You have a motion on the floor already.
Okay. And did we read that?
I did read it a couple of times, I believe.
Okay, then let me restate the motion, that the committee directs staff to add a definition of first credential program prior to R277-731 coming before the full board in October. All those in favor? Aye. Any opposed? Seeing none, that passes unanimously. Thank you. Let's go to the main motion.
make the
And
motion.
Board Member Hall.
Make the motion that the committee approve R277-731 Catalyst Center Grant Program, Policy Draft 1 is amended on first reading and forward to the board for approval on second and final reading.
Okay, the motion before the committee is that the committee approve R277-731 Catalyst Center Grant Program Policy Draft 1 as amended on first reading and forward to the board for approval on second and final reading. All those in favor? Aye. Any opposed? Motion passes unanimously. Thank you. Our next action item is 1.5. This is the 21X project. And why don't we I'll follow Chair Hymas's lead, and we'll say a 7-minute break. And we'll come back in 7 minutes. Thank you. Okay, I'd like to welcome everyone back to our Law and License. Oh, Deputy Newey.
She's in Finance Committee. I think she wanted us to just go ahead without her.
Okay. So let's go to the item 1.5. This is Project 21X. Board Member Bogus is the lead on this. And I know that there was some, and I don't want to say who, and I don't want to indicate maybe they're on this committee or not, but my preference is whenever we have a board member sponsored application that we give that member time to discuss it. I know that our bylaws don't address it, our policies don't, some members aren't fond of that. But I think as a courtesy, we owe that to them. So I have invited Board Member Bogus to speak to her submission. And I've allocated 5 minutes for that. And with that, Board Member Bogus.
Yes, sir. I appreciate that. So, interestingly enough, the term 21X is a little misleading because when we started this endeavor a year ago, believe it or not, is when the first meetings started to happen, kind of addressing the ongoing issues we see in these 4 rules, and it came from the fact that we knew we would have to move and combine different parts of rules and other rules. It wasn't meant to build this whole new thing. It's not a whole new thing. It's merely just mobilized language from 215 and 217 into 210, and our policy team did a great job working all that language over into 210. And I will tell you why that needs to happen. And the perfect example was a conversation I had with a teacher just this week. She called in, she said, "I don't know why you're doing these presumptive penalties now." And I had to say, we've always done them. But most of our teachers don't even know they exist. And then she started questioning the standards. And I said, "Friend, you are reading from the effective educator standards. You're not reading from the teacher standards." So by and large, our teachers don't fully understand that this is the code they're held to for licensing issues. And then the third reason we see this combined linear thing in what is our policy team has determined would be 210 is because the questions, what do these words mean, always come back to us. And just yesterday in the safety bill, Member Carey amended the definitions, and it's just not common practice. I know we have our 277-100, but it's very rare to separate the definitions from the rule itself. It just is not something that I think we should do. And if we're getting that many questions on this, I think it's important that teachers know what these words mean. And I think it's important that we have that in a space that's all aligned. So what looks like something big is actually really something quite small. The side-by-side document makes that very, very clear so that we can understand what's moved, what was originally there. And then some of the questions that I've had are very interesting to me because it's existing language. Just because it's green doesn't mean it's new. It's language that already exists in 215 or 217. And so as we go through this, that's there. And I think if I could explain this in like a word picture, if you can imagine when you go to the bank and you put a bunch of coins in the bank and it's chaotic and they cycle down and they just go into their correct spots. I think that is the way I would explain this. It's been very much so streamlined so that we know what we mean in terms of the 5 categories. The language is not new. It just articulates what we mean in terms of an obligation to a student, obligation to the profession, obligation to parents, and obligation to your peers. And so it's very, very clear, in my opinion. And there are spaces in here where we took and did a deep dive into what other state standards are so that we could compare and contrast. What is the language we're using? What is the language they're using? Why are they using that language? How does that precipitate the end result? And then ultimately preserves due process. And so I will tell you, I've learned a lot. 60 meetings into this, right? I've learned a lot. I've talked to a lot of people. I've talked to a lot of educators, and nothing makes you more self-reflective than working through this, because every move you make in the classroom, you have to really be reflective of, and how the decisions you make as an educator every day would be impacted by what's written here. And so 12 months later, this is what we have. I know there are some amendments coming. I think they're great. I know Member Bollinger and I had a conversation about a couple things, and then I've even reading it today, I found a couple other things that I was like, there you go, which is why we have the board, right? To make certain that we get the best final product. But I think we're in a really great space. We've had a lot of eyes on this, and so I'm super excited to see what you're doing today. Do you have any other questions for me before? I think that's about 3 minutes, but do you have any other questions before my 5 minutes is up?
That was actually 4 minutes and 44 seconds. So
Oh, well,
we're
my
down
teacher
to the
time
last.
clock, my internal time clock is off, Member Carey.
No, thank you for that, Member Bogus, and thank you for the work that you've done on this. I've heard ruminations of the activity, and then I've had the opportunity to review it, so thank you for that.
You're
Look
welcome.
forward to the discussion.
All right.
So with that, Member Rasmussen, or Director Rasmussen.
Definitely not member.
Excuse me. And excuse me, can she ask, are there general questions? Could I just ask a couple of, one actually, one
Sure.
only general question in her 15 seconds that
Yeah,
are remaining?
please.
I just wondered, you said you've had a lot of eyes on this,
Mhm.
but have you talked to a range of teachers? Have you talked to HR directors? Have you talked to superintendents? Have you talked to UPAC members, past or current? Have you talked to any of those groups about these changes?
So I've talked to a good cross-section of educators. I don't know.
Teachers,
Yes.
is that what you mean?
Teachers, yeah.
Okay.
I ran it by one or two principals that I've worked with in my career. Not any current that I'm currently under, but that I really valued their opinion and their execution of creating and cultivating a culture of learning in their building, and systeming very high standards among their faculty, and what they thought about it. As far as HR directors, I don't know what that would have to do with it, so no, I didn't go there. And I did speak with one superintendent.
One superintendent. Okay, I was just interested in how many stakeholders you've actually spoken with. So that gives me a good idea. Thank you. Well, that gives me a good idea.
You want a
Thanks.
number?
No.
Okay.
I just, your explanation, your examples were helpful.
Okay, thank you.
So Board Member Bogus suggested we begin with 210, so let's do that. And you want to sit there? Oh, any other questions for Board Member Bogus?
I do have one
Please.
question, Chair, please. Member Bogus, if you can just help us understand, typically there's a reason, a concern we're trying to solve or a problem we're trying to solve, the purpose behind the changes. You kind of talked about how to go into, lined up correctly. Can you just help us understand as a committee what the purpose of the major changes are, if you can speak to that?
So I would argue that there's not very many major changes. There are changes that clarify things. So in executive session every month, we ask a lot of questions that could be handled through better process. And so, for example, in here it talks about a cover sheet. There is a mock-up of a cover sheet because we thought that through very, very clearly. Like, what should that look like so that the board is better prepared, executive session can function more swiftly and smoothly. There was also the thought about we're spending a lot of time on educators who don't actually violate the standards, and that comes into executive session. How can we streamline that so that there's a better efficiency? and then clarity. So, for example, in the current 215, the rule itself is in conflict with itself in multiple places. And there are two words. One is minimal, the other is minor. They seem to be used interchangeably, but there's no definition of their meaning. And they reference 217, and in 217, nothing is minor. There's nothing identified as a minor violation in 217. So our rules themselves are in conflict within the rule. Every single one of them has an internal conflict. And then they are in conflict with each other. And part of the reason that exists is because they're amended in isolation. And so we're not considering 215 and 210 when we start to amend 217, which precipitated the idea that in order to really fix these things and prevent that chaos in the future is to combine them into a single document so that we're always on the same page and we're always reconciling and doing our due diligence to ensure that we're not in a place where we create something that's in conflict with itself or incongruent. And then I think the last thing is to just be fair and sporting through that process. I think that sometimes when we sit and we review these things, we go, really? Is that what we meant by that? And so I'm very hopeful that by parsing those out while keeping the same standards, but parsing them out, we have a much better understanding of what these words mean as they relate to teachers relating to students, teachers relating to each other, teachers relating to the profession and to their peers. And if you look at the standards in other states, I think we've really reached a place that's I don't know, quite good. I think it's some of the best work our staff has ever done. And I'm really proud of the work that they've done in this area. And so I like it. I noticed a few things myself. I know you noticed a few things. And so I hope that answers your question without being too verbose. Yeah.
Thank you, Board Member Bogus. Yeah, and then if we have a question, Board Member Boggs, we can do that. So it's my understanding that Chief Audit Executive Davis, you worked with Member Bogus on this extensively, so why don't we have you come up, and then Director Rasmussen, you're available for questions as well. I just want to start with a general question, and one of the two of you, whoever feels most appropriate to answer this. It's my understanding that our current set of rules came about generally, and I wasn't here for this, but as a compromise or a solution to a legal action that was brought. And I want to make sure that that is no longer applicable, that that's something that we don't need to worry about, that is something that we should consider as we look at these rules, but I want to start with that understanding first. And Director Rasmussen, you turned on your light, so please.
Yeah, so I think it was about 2016. There were some appeals to two UPAC cases that went to the appellate courts by the UE as part of that we had a mediated settlement to those two cases that included that we would have a task force of stakeholders that did a number of things. One of the things they did was review the rules in depth and made a number of proposals for changes to those rules, which the board adopted. That the agreement to settle the mediation was that there would be a task force and that those rules would be reviewed. The agreement was not that the rules could never be changed, just that we would review those. And we did have a task force at that time that went through the rules in depth and recommended a number of changes to the board.
So following up on that, is what legal considerations, if any, and if this is more appropriate for executive session, then indicate that, but what considerations, if any, legally does this body have to be aware of as we consider these proposals?
I don't think there's anything from that prior settlement that should restrict the board at this time. I mean, the board can evaluate and determine whether they think changes are necessary to the rules. I mean, we still need to bear in mind the issues that led to those cases. Those cases were predicated on concerns about fairness and consistency with past practice, was one of the primary motivators behind those appeals, as I recall. But the board doesn't have a legal obligation to never change the rules, change the presumptions, anything like that as a result of that settlement.
Okay, thank you. Board Member Lear?
And this is not something I want to belabor today. I don't think that would be appropriate or necessary, but I do believe that some of the underlying principles, and you mentioned this in passing, Ben, but I think some of the underlying principles that prompted that settlement and the mediation and the outcome cannot be forgotten. I don't think there would be a court that would say those underlying principles are no longer important. And I recall, and this is coming back to me, Dr. Sarah Jones, who spoke this morning, sort of prompted that reminder that I'd even lost after 9 years. But I think that the matrix, for instance, was one of the pieces that, and some consistency by UPAC with past cases was part of that mediation and understanding that. And that, for instance, I don't think should just be thrown out or not considered important anymore as a result of new rules. So that's just one example of a principle that I think we still would want to hold to based on that. And we could based on that previous settlement and process. So, and I know we could find more information if we were inclined, if we need it. But I just want to clarify that I think some of those principles would still be legally important in our revisions, review, whatever you want to call it.
Thank you, Board Member Lear. So let's start with, I believe there's several rules.
Chair.
Oh, I'm sorry.
Sounds like the matrix is preserved in here. That's what.
I don't know. I'm just
Okay. Would that,
talk about it?
well, let me ask Chief Audit Executive Davis, is the matrix preserved in, we're looking at Rule 210 now. Is it in 210?
So Chief Audit Executive Debbie Davis, and yes, I did help somewhat with some of the suggestions to this rule. Not unusual. Internal audit does that frequently. With any rule, you would want to identify the data points. So in existing rule, there are data points that are put into a matrix. The revisions to the rule, or even some of the existing language, would suggest that yes, there's still data points. Yes, that could still be put into a matrix. So yes, the principle, as you were mentioning, of a matrix of making sure that there's precedence is included in the rule.
And
Chair, can I speak to this just briefly?
please.
So I think there may be a little, I just want to make clear what the matrix is. I'm putting up the UPAC webpage on the screen so the board can see there. What we do is we have a spreadsheet that we keep track of every UPAC case that shows a little bit about the facts, what were the considerations were, and what the discipline turned out to be. I didn't see any reference to this matrix in the rule. This was something we agreed to keep on an ongoing basis as a part of that settlement. I don't think we need to have it in the rule to keep maintaining it. And wouldn't have any plan to change that if even if these changes passed. But the matrix itself is not referenced in the rule or included in the rule that I saw.
I see. And what you're saying is it's not included in the current rule either.
No.
This is just something that we do as part of the agreement that was made. And it's my understanding we keep this to demonstrate a consistency.
Court case law requires us to be consistent with past practice, and so this is something that we use during hearings, during deliberations of cases, so that we can see how we've handled other cases in the past. We have UPAC members that are very fluent with this matrix and go looking in there and comparing other cases to what we're talking about, so that we can see how we've handled things in the past.
And to be clear, this rule, the proposed changes don't impact this to any degree. Is that your understanding?
They would, to the extent that they're changing some of the presumptions. I think if you change the presumptions, that you're not gonna follow past practice if you're changing and you've publicized that you're gonna handle presumptions differently. But so if that makes sense, they would change this in the effect that it is making a different paradigm for how we look at cases, having different penalties for things.
But, and it was my understanding based on what you said earlier, this board has the right to do that. If we want to change the level of presumptions, if we want to increase them or decrease them, this body has that ability.
I believe if the board follows the rulemaking process and, does and complies with the Rulemaking Act, I don't see why that would not be possible.
Okay. Any questions from the body?
Do you want us to just start in with some concerns that have been brought to our attention? Is that that are very, and I don't personally, I'll bring these concerns forward. I'm not going to be very explicit about who brought them, except sometimes generally, but I don't really need or want a response from Member Bogus or anybody, really. These are just concerns that I feel have not been adequately addressed, and maybe discussion will lead to some of responses, but I think it will be far too weighty if we just have everything merits a response. So I don't need a response.
I
Is that
understand, and I think that's fair to a degree, but I think it would be unfair not to give the opportunity to have those concerns also addressed, right? Because I don't want to leave the impression that those are unresolvable or there's no interest in resolution of those. So I would ask, I mean, it would be your time, but I would ask that if there are weightier matters that you really would like to say, look, I'm concerned about this, how would we address this or fix this? I would be more interested in that than just a litany of, look, these are the problems I have, because there's things I like, there's things I don't like, but I do think everyone should be given the opportunity to address.
Could we
a
wait till
concern.
the end then of my comments, and then if Member Bogus wants to address them? I feel like it's unproductive to have a constant back and forth. That's
I
what I'm
understand.
saying.
So if you want to proceed that way, and then if we could just play it by ear, and then we'll
That's
see how
fine.
that goes.
Yeah,
Thank you.
because I absolutely agree. I don't think that it should be given that what I'm saying is it trumps what the rule says. I just want to raise some issues.
Understood.
So first of all, I've spoken to a number of attorneys who work with school districts. I've spoken to several superintendents, and I've reached out to contacted any HR directors. I've spoken to some former UPAC members and one former UPAC investigator. So I've tried to reach a number of people who have some familiarity with the process. Here are some of my concerns. And again, if you feel like you want to at the end, if you would just respond to any of those. And I say this very respectfully because I think you have put a lot of work into this. First of all, I've heard that from several people, these are not amendments. This is a complete overhaul of the disciplinary process, including this new level of intent system that has not been introduced before. And this would require, and Ben referenced the requirements of the rule writing process that could lead to changes. I agree that gives some time for notice. I think what it would probably prompt are administrative hearings that would then maybe further express concerns, but that will just prolong the process. So I'm not. I think the rule writing process is helpful, but I personally think changes of this nature need more time to process with a broad variety of stakeholders. So that was one concern. Another constant that I heard from attorneys especially was that these rules introduce an effectiveness of teacher effectiveness factor that has never been UPAC's purview before. That has been an employment decision if a teacher is effective or not. But now there's language in the rule that talks about teacher effectiveness, and that the words might be a little different than that, but those have never been discussed or under review by UPAC before. And that was a grave concern to attorneys who work closely with their LEAs on employment concerns. So that was one of the big deals.
Carol, while you made the mistake of taking a breath. So I just want to ask a question.
I rarely.
I've heard that same concern. Can someone point to
And I
where
didn't.
that may exist or may not exist? Where we're evaluating teacher effectiveness?
Let me see if I can find it quickly. You're way ahead of me in terms of reading.
I'm sorry. I thought that was something that would be known. So please continue. And
She said she said line. Amanda said line 550. Let me see if I've got it in one of my. One of my letters. And I don't have it. I don't have an exact reference. I didn't look at. Let's look at line 550. Is that what you said, Amanda?
Board member, please continue. I
Okay.
didn't mean to
You just
interrupt.
completely derailed me.
I
That's
apologize.
fine. No.
You may start over.
No. The other, I think I can, with a little bit of time, find some examples of that. I don't have them. I think that there's some that are implied and some that are a little more specific. I'm concerned that the letter of education, it's not clear. Member Bogus mentioned that she thought the current UPAC rules were internally inconsistent or conflicting. I found these rules internally conflicting. In one place, letter of education is crossed out. And as all of us know, most of us know, letter of education is just telling an educator who may have erred in a more minor way that this should not be happening. It was crossed out in one place, but then in other places it's still listed in the various rules. And if the intention, it's internally conflicting anyway, but if the intention is to do away with the letter of education, I think that would be a big concern, because that would mean that there is, and then also the language was used in connection with warning that this was an action, which would then trigger an educator's opportunity for due process, a hearing. If it's just an educating letter, there's no attack on the property right or property interest. It's just, please be careful about this in the future. If that's no longer there, and even a warning letter is an action, then it triggers due process, which, I don't know, doubles the load of UPAC, considerably increases the load of UPAC. So that was a concern with some of the folks that I heard from, saying, was this the intention? And if it wasn't, why was it crossed out one place and left in others? That's the letter of education. There were some concerns that were specific to conduct outside of school that were not illegal, but that could be reported. And then, again, without a letter of education, it would trigger some right of a teacher. And it's usually been the case, and there are some, we can point to some examples to the contrary, but it's usually been the case that off-duty behavior that doesn't rise to the level of anything that's illegal has not been the kind of thing that has been a UPAC issue. Teachers are able to have a life. Another attorney told me that he feels that the terms are vague and ambiguous, overly broad, and overly complicated. Just to give one example, the term legal space has no technical legal meaning. It's, I have no idea what that means. That's just one example. Another is on line 122 and 130, and this is in 210 through 130, talks about boundary violation environment. And that, again, is not something that is well defined or well understood or commonly used. Let's see. Line 167 prohibits interviewing or surveying a student without informed consent, but the term interview and survey is so broad it could include a teacher asking students questions during a class discussion or having a conversation with the student after class. Another line 171 through 173 prohibits soliciting, compelling, rewarding, or otherwise influencing agreement with an expressed attestation, signed agreement, statement, contractual obligation. It's entirely unclear what this means, what makes it impossible for an LEA or which makes it impossible for an LEA or UPAC members to enforce or train effectively on this. There's a definition of reasonable that is more colloquial than it is legal, and that makes it difficult for educators to understand as well. Other things, yes, I don't take
Chair, I'm sorry, I'm
Okay.
wait to be called on.
I will take a breath and let others, those were some of the things that came to my attention. I've got another list that is a little more general that I can come back to if time permits.
I do want to give Board Member Bogus or Chief Audit Executive Davis the opportunity again to respond to those thoughts or concerns that were shared with you. Board Member Bogus?
So if Debbie, if please turn on your mic and we can tag team. So I appreciate this. I would argue this is absolutely not an overhaul. I think it realigns things so that they are much more clear than they ever have been. The level of intent is already in 217, but it's just this wicked mess of cat yarn where the cat's playing with the yarn, and it needed to be untangled in order to really understand where we're at and all of those things. So that idea and language to that effect is already there. It's just untangled, and the amendments reflect the untangling of that. With regard to public hearing and process, that's why we're here, right? And this is not new. The first meeting on this was last September, and it has graduated like an increased in magnitude over the past year. So this is not new. I think when you talk about that it introduces teacher effectiveness, if you look at section 550 on line 550, where Member Bollinger brought up, there is a section that speaks to that as an overarching idea of a standard, not the nitty-gritty of evaluating performance. So the standards that teachers should be held to. So for example, it opens up with that teachers shall perform job duties consistent and compliant with all federal, state, and local laws and policies. Believe it or not, that's current language or very similar to the current language in our document. And so it's mobilized language, and it might have minor tweaks, but it's not new. It's just put under this heading so that we understand where we're at. We're about standards of performance, not intricacies of performance. If you look at the second one, that they must demonstrate the ability and skill necessary to satisfactorily complete their professional job duties. As an educator, it should be a standard that we should tell those who are superior to us if we lack the capacity or need the training to do our job well. That is a professional standard. Other professionals do that. It should be no different in education. If I'm asked to do something and I don't have the skills to do it or I don't fully understand it, that's important. So these are standards. We're not evaluating performance in these standards. We're setting standards of performance, and those are two different things. I believe these are very specific. The letter of education, nothing precludes UPAC from sending a letter of education. Nothing in this rule precludes that. However, it doesn't include it because it would streamline the process. So a letter of education has previously been defined as that which does not violate standards. but could lead to a violation of standards. If UPAC wants to send those letters, by all means, go right ahead. I have no issue with that. I just don't understand why the board would be adjudicating that if they've found no violation of standards. That's why it's not here. They want to send them, I don't care. I don't know where it's addressing conduct outside of school other than that is already in our previous rules. So I would love for you to point that out, because the DUIs and the violations of code, the theft, things like that, I would love to see that, because I don't know. Legal space, to me, even though it's not a legal word, is very well defined. So, for example, civil rights do not end at the schoolhouse door, and when teachers are taking kids' phones and searching them, that's a violation of their civil rights. New Jersey versus TLO is very clear. It's not something that's negotiated in the education space. When you get your administrative degree, you train on it, you understand it, there's a big assessment over it, and teachers searching backpacks as disciplinary measures. You can't do that. You have to have reasonable suspicion. That's legal space. When you go into violating the rights of a child, that's legal space. When you tell a child to enter into a contract that they cannot legally enter into, that is legal space. A 12-year-old cannot accept a privacy policy. And so that would be just a few examples of where that's at, where the rights of the child are intact and the educator can't violate those rights outside the scope of the law and case law. I think if we go to a boundary violation environment, the landscape of education has changed. Member Lear, I know that's no secret to you. We're in a space where we have virtual schools. And by virtual, I mean literally kids wear little masks, right? And so it's very hard in teacher standards to define what that looks like when a kid is wearing a thing, but there's a teacher there. They can see that teacher, right? They can see them in their virtual reality mask. And then there's the online realm and the realm that exists in the facilitator relationship that happens mostly online, where you're never really face to face. And so those environments are cited to address the ever-growing educational landscape and how it's expanded and changed through the years. And I think perhaps to address the concerns with interview and survey, this is already against the law, that you can't interview or survey a kid without parental consent. That is already in violation of Utah code. It just really merely brings it to the standards and pulls it out and says, hey, this is not okay. If you would like, I think it would be a great idea to define those two, perhaps link them to the appropriate code lines and put that in there. I think that would really tighten that up. I think it's a good idea. Thank you for pointing it out. 173, we're talking about coerced statements or affirmations. You have to sign something that says you believe in these things in order to participate. We shouldn't be requiring our kids to affirm believing in anything in order to participate in the public school system, especially a system in which they are compelled to attend. So the coerced statements of belief, and if we need to define that and put a definition there, I think it's important. But when educators engage in this practice of affirming belief, that's nothing more than coerced speech, which is a violation of the First Amendment. And so the definition of reasonable, I'll just be honest and respectfully, because I definitely respect your opinion. I found it odd that you had articulated that it's easier for teachers to understand legal language than colloquial language. And I would argue the opposite, that it's easier for educators to understand colloquial language than legal language. If it is the will of this committee and the will of the body to produce a legal definition for reasonable, I think that's okay. The goal is to really help everyone understand where we're at. The legal definition of reasonable, I think, is, for example, what a similar person in that context would have assumed to be reasonable. And I was always taught, I had a great English teacher in high school, that you never define a word with a word. And so we say reasonable, and then we circle around to reasonable. And so I would love your advice and your feedback to make that better, to tighten it up, to put it in a space where we're not using vague, ambiguous language. I've had some conversations and I would agree with you. I think there's some words that need to be defined as opposed to removed. One is the word health, just as an example. That is existing language. It is existing language in 17. I asked that question yesterday. What do we mean by this? Because it's already in the standards. It's used in this one because it's ported language. It's just moved from one rule, and we're taking that same language and putting it in this new 210. But that is an example of a word that probably needs to be defined by this board. Because if that's a standard, then we need to know what we mean by that. And so with that, those are the notes that I took very fast. You spoke very quickly, and I hope I've answered all your questions.
Thank you, Member Bogus.
Did you have anything to say?
Chief Auditor Executive Davis, please.
So first on the letter of education, I went through the 3 drafts, the 210, the 211, and 217, and did a quick search. Letter of education has been struck in 210, so that's accurate. It is included in 211, and I wonder if that was oversight as the changes to 211 came very late in the process, but it was an attempt to say, what are we missing? What did we do right? Or what did we not get? And so it's accurate in 211. There are still instances where letter of education is included. So that would have to be addressed, that it is included in 211. It
Is
appears.
the, oh,
Can I just query whether, did you intend to keep it in or intend to take it out?
Do we know?
You can answer.
The intent was to take it out, as was mentioned.
That's all I need. That's
Okay,
all I need.
yes.
Thank
Yes, so that, and then I would just also express support for the fact that the environment in education is changing, and a lot of internal audits perspective that we were able to bring to considerations or questions about the existing rules come because we maintain the public education hotline, and we're up to about 4,700 concerns over the past 6 or 7 years, and we just keep getting more and more. And every day when I think we've seen it all, there's nothing we haven't seen. We always see something new. So in trying to say like, well, what should boundary violation capture? It's incredibly challenging to try and figure out what should be included there because the landscape is changing so fast right now. So just wanted you to have that perspective on that based on our work with the hotline.
okay, thank you. So can I just go through some lines then with just questions that I had? And let's start with 610, and I'm sorry that these might not necessarily go in order. So this is R277, 210, and 610 is an administrator, and then we go through the duties of the administrator. Because this is in UPAC, is there language that limits this to an administrator with an educator license, or do you intend to have this applied to all administrators?
So a lot of this language, just for clarity and transparency, is already in the 330. I believe it's 330. And I do believe it applies to all administrators because in the capacity of 330, it already applies to all administrators. And again, it's a standard. It's not a performance thing. And I think that the ongoing issue when it comes to adjudicating administrators is some of the things here, though they apply, administrators work in a different capacity. They have a higher level of trust and a responsibility to supervise well and in for lack of a better terminology, care for their staff and the students in that building. But yet we don't call that out and we don't set a standard for that in something that can be adjudicated if we have a grievous violation of the public trust in that position. And so this just takes all that already existing language and it pulls it over and says we take this seriously, and if administrators are going to violate this, then we're going to act on that. And again, that's not a big, huge whoop-de-doo, but
I think it is, and I think that we do need to hold administrators accountable. I'm just curious, and Director Rasmussen, I read this to say any administrator would be subject to these provisions which are in our UPAC rule, do we have the legal authority at this time to do that? Or can we only hold those administrators with an educator license available?
So UPAC only has jurisdiction over administrators with educator licenses. I mean, you could put this standard in there for administrators at charter schools, for example, that don't get those licenses, but you wouldn't be able to take them through the UPAC process if they violated those standards.
But as this reads now, are we saying all administrators? Like, would we have to put an administrator with an educator license to limit that? Or do you feel this is appropriate the way it is?
Administrator isn't defined, but I don't think that it's something that's going to cause that much confusion. I think what would come to UPAC would only be licensed cases.
Member Carey, may I add something?
Please.
Okay, I went back to R277330, which is the effective educator standards, which does define administrator as having the same meaning defined in 53G-11-501-1. And if you go over there, it says administrator means an individual who supervises educators and holds an appropriate license. So administrator is defined elsewhere, and perhaps if the board wanted to, you could use that same definition here just for clarity as to who does this apply to. But again, that's just wanted to bring that clarity.
So you're saying that by definition, they already are licensed?
As defined in code, and then it would be if this rule is going to follow that definition as is done in R277330.
Okay. And I asked you this before, Chief Audit Executive Davis. In terms of the number of complaints we have coming into our hotline regarding administrators, what percentage of our total complaints that come into the hotline are concerning administrators?
So, and I think I mentioned this before, we're currently not tracking concerns based on the position that the allegation is against. So it's hard to bring that up. However, but the categories we're using, for example, we have a number of safety categories. We do have educator misconduct. We do have special education. Right now on the hotline, we're tracking based on the primary category, and we make referrals accordingly. A number of those do go to UPAC regarding licensed educators. Are there concerns that we could send to UPAC that we're not currently sending? We could. We know it's an already overwhelmed system, and we're trying to get people to the place where they can get resolution the quickest. So for example, if it's a special education concern, it could involve an educator or an administrator that's not doing something that they should. But if it's, hey, we need to get it to dispute resolution quickly, then we're going to refer more on a special education path than, hey, UPAC, you need to take care of this, unless it's like, oh, this is so egregious, we absolutely have to send it to UPAC. So unfortunately, I do not have a percentage, but there is a number. Last year, just for context, last year on the hotline, we received 705 concerns, allegations coming in. And for context, this year, since we just pulled the information, in the first quarter, so July, August, September, last year, we received 139 allegations. Through July and August this year, we're already at 138. So we're well above this year where we have been previously, if that's helpful.
It is. If we go to line 636 and 637. Is this same requirement in 636 and 637 imposed upon the educator?
I believe so.
Okay, can you show me where that is? Line 636 and 637.
That is, if you look at 632 and 633, that's part of an educator's obligation.
Oh, I see. Okay.
Thank you, Ben.
I thought this was under the administrator part. Thank you. Then line 661. In fulfillment of an educator's obligation to the profession, an educator shall exert every effort to raise professional standards. If an educator fails to do that, and Director Rasmussen, I would like your interpretation, because should this pass, this would come to your purview. as I read this, and if an educator fails to do that, shall exert every effort to raise professional standards, would that be a violation of a UPAC rule?
Well, this is the UPAC rules. So
Should it pass, right?
if this passes, this would be reportable to UPAC, yes.
And given the and I would ask, well, again, I'm going to direct this to Director Rasmussen because I'm really more concerned not about the rationale or the reason, but more on the practical actual impact. And because this would come to UPAC, I will direct this to you under the rules as they are currently being proposed. Should this complaint come to UPAC and you find it to be credible, based on the, I'll call it the matrix that's being provided here in terms of sanctions or consequences allowed, where would this fall?
I guess that would depend on how you interpret these definitions of whether it's minor through egregious. I would suspect it would fall somewhere in the minor to moderate category, but that would be for the board or for UPAC to interpret how serious they think the particular violation is. I mean, this would be creating a whole new class of cases that are coming to UPAC and be flooding us with a number of new reports, number of new things that LEAs have to report to UPAC that we're not currently dealing with.
So Board Member Bogus, let me ask you, how do you see this, when you came up with this language, they shall exert every effort, what does that look like to you? Like, what was the end result that you were aiming for in that?
The end result would be raising the bar as educators. I think that so often in some schools and as a culture, we've become accustomed to accepting mediocrity among ourselves in how we dress, in how we present ourselves. Teachers come out and they want to be viewed as professionals, but they don't speak like professionals. They don't dress like professionals. And to be very fair, many of our surrounding states have very similar language in their standards. It's the will of the body. It's a policy decision as to whether or not we would want to keep something like this. But I think we have to remember that this is a standard, and maybe it's not the place to put it. We can debate that, but I do think we need to encourage our educators to raise the bar. I think that's important, and I think it's important to call out to improve service to students, to promote a culture in which the exercise of professional judgment exists, where it's not just some haphazard things. I mean, teachers have hard jobs. They make, somebody said at one point, they make 1,500 decisions before lunch. And then I wonder why I'm so tired at the end of the day, right? But I do think that we are in a place of coerced trust, if you will. Our students are compulsed by law to be there. And I think if we're going to do that, we need to take it seriously and we need to raise the bar.
And I'm fine with all of that. I just get very concerned that, one, in how UPAC would evaluate, because they're very specific terms, right?
Mm-hmm.
Exert every effort. And I don't know if anyone else seen this cartoon, but it said, the beating shall continue until morale improves. And I look at this and I'm like, I agree. We need to raise standards. But I don't know if the best way to get there is well, thank you for that. I'm just trying to better understand how that would look, how that would be applied. and it's an interesting concept, and I'm sure a sociologist has done the math. Can you measure effort effectively? And I think the answer is out there. Let
Yeah.
me go to
Are you asking for an answer?
No.
No, okay.
655.
Did you say 655?
Yeah, 655. I'm sorry,
Okay.
these aren't in order, but these just some I came up with. Some educators wrote me. And again, Director Rasmussen, I'm going to direct this to you because this would come to you should this rule pass. It says may not permit commercial or personal exploitation of the educator's professional position. How would you define that? What does that look like to you?
It's a good question. I mean, as I read that, I think of a number of cases that we've started to see lately of educators with side hustles on Instagram or TikTok that are making videos in their classroom and getting a lot of money or gifts sent to them for it. That could potentially be a whole, violations of the way that's written. But I mean, it's kind of broad. I mean, it could be interpreted to cover probably quite a few things depending on how circumstances look.
So I know that some law enforcement, they don't permit you to make a TikTok if you're sitting in a squad car, if you're in a police uniform. And so we would, under this rule, you would see the application possibly be, yeah, you shouldn't be using the gym to film your next viral video. Okay, thank you.
May I offer something on this one?
There's just a whole bunch I have to go through. So I'm
I-
really just trying
I
to
promise I'll make it quick.
Oh, that's okay. Let's go to
Okay.
677. And Board Member Boggs, like I said, it was a courtesy to have you here.
Mhm.
And I'm really just trying to get through these because we're still on 210,
Yeah.
right? We have
Mhm.
plenty to go. So let's go to 677 through 668.
So your numbers went in reverse. You said 677 to 668,
Oh,
and I
can we go to 668? Yeah, so again, Director Rasmussen, let me direct this to you. But it says here, shall practice the profession only with proper licensing and endorsements, and shall oppose the practice of the profession by unqualified individuals. And I guess my concern here is not the licensure requirements or keeping unqualified individuals out, but it appears to say that there is now a requirement to oppose those practices. Is that interpretation correct based on the language that you see there?
Yes, it says shall oppose the practice of the profession by unqualified individuals.
So we would be arguably compelling speech or compelling particular, to take a particular position, or you would be in violation of this proposed rule?
I think by the plain language, yes.
Okay, that's the way I interpret it. CEA Davis, when you helped assist in the crafting of this language, what was your intention with that language?
I don't remember exactly. I believe this actually came from another state. And so there was hey, let's take what things from other states that the board might want to consider and include it. And then, of course, through the process of the board, it could be removed. So I don't know that it was broader than that, at least for me.
Okay. And Board Member Baga, same question. Were
so
you trying to compel speech or trying to compel behavior with this language?
no, we're trying to raise the bar inside institutions where, for example, all year long, we have a substitute teacher for 6th grade and they have no credential, they have no training, but they're just there the whole year. Sort of a thing that we need to raise the bar inside our institutions and advocate for our students in that capacity. Not trying, well, you know me, I don't like compelled speech. So if that's how it reads, that certainly was not the intention and it should be changed, but it was more to address practice than to be any sort of compelled political position.
Okay. And that's what I would think. I'm just concerned with the plain language, how that would be interpreted. And then Director Rasmussen, and maybe this actually goes to Dr. Height. The way I read the plain language of 667, it says that you can only practice teaching with the proper licensing and endorsements. But the Catalyst Centers, we can't require a license or an endorsement, can we?
Well, that's one specific instance. We have rules that require proper licensing and endorsement. This is just kind of oddly placing that language in the educator standards. This is not something that we wouldn't discipline someone for teaching a class without a license right now.
Well, you couldn't.
Well,
UPAC couldn't do that, could it?
Because it's more of an LEA issue as to who they're putting in their classroom, whether they have a license or endorsement. It seems kind of oddly placed in the educator standards to put this particular requirement there.
Okay. But in terms of the language itself, there is no issue. It's rather the placement, like making it a violation of a UPAC rule? Okay. And then if we just go to 396, I'm sorry, I know I'm taking a lot of time from the committee, but these are the questions that I had. Yeah, yes. And Director Rasmussen, it's my understanding that our current UPAC rules define pattern or repetitive distinctly. Is that correct?
The current UPAC rules have a definition for pattern or repetitive that is more flexible and allows UPAC and the board to really take a look at the circumstances. If you look at this definition, this was one concern I had as I was reviewing the final version of this, is that it requires that you show each and every one of those elements to prove that there's a pattern or to prove that it's repetitive. You can have a pattern right now when there's only one student. This one would require more than one student to have a pattern. That's one example. So this is a very, very prescriptive, much more prescriptive than the current rule.
Can you think of a reason why we would want more than one student to show a pattern or repetitive? Because what I'm thinking is if you had the same student who was being inappropriately engaged by an educator, would that fall under this new definition?
I think what we have right now is we look at whether there's more than one student to make that determination, but we don't require it. So it's a consideration as opposed to a requirement, and I think that's helpful for the board's authority and for UPAC as they review these cases, as they're able to look at the facts and look at things on a case-by-case basis and not be fixed as to how they interpret that. I think that especially where the board often wants to find that there's a pattern, I think they have more authority to do so when they have flexibility in looking at the facts.
And I understand that's our current rule. What I'm asking is, as the director of UPAC, if this was the rule, would this require, in order to be repetitive, do I need different students, or could it be the same student where the misconduct was falling upon?
As this is written, it says that misconduct involves more than one student or individual, so that would have to be more than one.
I think on line 400 that should be an or.
Well, okay, so that would probably be something they need to make a motion on.
Yeah.
Yep. Go ahead. CEA Davis.
Maybe 2 points. If you look at where is the term pattern or repetitive that is defined used, it's currently used only, I believe, in the aggravating or mitigating circumstances. There is also built into the 5 levels of intent, so from minor to egregious, where that's where it also picks up, is it one or more individuals? So it is built in a little bit differently there, just a different way to think about it, but the one or more is also picked up in those levels as well. So I just wanted to point that out.
No, and I appreciate that and I understand that. But here, when we're talking about in order to find a pattern or repetitive, it appears to me that the plain language says it can't be the same student that is being harmed. It has to be a different student in order for this provision to kick in. Is that your understanding, CEA Davis?
So I think with the and, then yes, that is problematic and it probably should be an or.
Okay, and what and are you referring to?
Is it line 400? Because it has A through E and, so it would have to be all of those things. And I believe the intent was it could be any of those.
Okay, so on line 400, by changing that to an or, even if it is one student, if it continues after documented warnings or action from administrators, then it would constitute a pattern or be repetitive? Okay.
It would need an amendment, sir.
Okay. And again, these are just questions, and I appreciate the answers. Let's go to lines 249 and 252. I know everybody's anxious to ask their questions, but I know. I just want to go through this because it just helps me better understand. So here I see that we've defined critical. Here we're defining egregious. And I think critical is defined on lines 230. If we just scroll up, we'll see critical. Oh, yep, let's keep going up, right there. So Director Rasmussen, and I'm sorry to put you on the spot like this, but I'm asking you because should we pass this, you would be responsible for the implementation and execution. As you read the definition of critical and you read the definition of egregious, what is the salient difference between those definitions in your opinion?
I think where the primary difference is going to be the mental state that is required, as I'm looking at it. Critical requires deliberate disregard for the educator's position of trust, and then egregious, it can be negligent, irresponsible, or deliberate disregard.
But doesn't that say the same thing in critical?
Well, deliberate disregard is in critical. I don't think the other two are.
Well, can we go back to critical and see? To me, it looks like the same standard for critical or egregious in the draft 3 that I'm reading. Is that Director Rasmussen?
Oh, you're right. I didn't read back further.
Well, no, say that part again where you say I'm right. Just one more time for the record.
You're right,
Yeah,
Chair
thank
Carey.
you. Okay. So, no, and I would assume that's the case. So the definition in draft 3 is the same for critical and egregious.
Looks like it.
Is there another standard set forth in this proposed rule in addition to egregious and critical?
There are 5 standards. There's minor, moderate, what's the middle? Serious.
And can we scroll up until we get to serious?
Mm-hmm. That's in the table in the presumption section. Yes. Let's see, there we go. So serious would be different in that it's disrespectful or shows indifference.
Okay, and so let me ask Chief Audit Executive Davis. It appears that the definition for egregious and critical are the same due to an error. Is the definition that we see under critical and egregious, is that the definition of critical or egregious?
The definition of critical is accurate to what was intended. It is the definition for egregious that is currently not accurate.
And is that definition available for egregious?
Yes. Would you
Okay.
like me to read it?
If you could, please.
So it's the same down to the last part, but instead of negligent, irresponsible, or shows deliberate disregard for the position, it would say flagrant, reckless, shows blatant disregard for the position or trust, or flouts the standards.
So you would have to meet that, standard to exact what violations under your proposal. So if somebody exhibits behavior that way, they would be sanctioned with a revocation of license?
Critical would be the top level, would it not?
Oh, critical comes before egregious? No, egregious is the top.
Okay.
That's right again. I have two more. I know, two more.
And you are correct that it would, as is currently proposed, but the board could change it, it is revocation.
Okay. And revocation would only be possible if it met that threshold. Is that correct?
10 or more years suspension.
Flouting the standards is part of egregious, which would be revocation. And then I just lost track of what you said.
No, I just want to, is revocation of license only possible if you meet the egregious standard under this proposal?
The egregious standard, and there are specific items in Utah code that require revocation, and those are listed in the presumptions.
Okay, but outside of those that are required,
Yes.
revocation is the only way to revocate a license under this proposal by meeting the egregious standard. Chief Audit Executive Davis?
My understanding, I'm not a lawyer, of course, but it would be yes, it has to meet the agreed, okay, the board does have, when you start looking at, hey, it comes and you would take into account aggravating or mitigating circumstances. And so it is possible if you came and said, oh, we think it's critical, and the board says, no, we think that's egregious, but at the level it does hit egregious, if there were aggravating or mitigating, that could sway, and it could be revoked at that point as well, I think.
Also, you need to look at lines 9, 15 through 32, which are specific things that also lead to revocation. Most of those are what she's alluded to come from statute, but also a number of things like murder. The one thing that leads to revocation that wouldn't necessarily be tied to that mental state is on line 931 through 32, which is the committing fraud, theft, or misappropriation of funds greater than $5,000.
Okay. And then just one more, and that's lines 212 through 214. And Director Rasmussen, again, I'll direct this towards you. A conviction is prima facie evidence that an educator engaged in or committed the allegations or elements necessary to support the basis of any criminal charge or violation of federal or state law. I believe I understand what was trying to be said with this language, but to me, the plain interpretation says if you have a conviction, you can use that conviction to support the basis of any criminal charge or violation. Is that interpretation right, or do you read this differently?
I'm not sure I understand why that's there or what it's saying. I think if they're trying to say it's prima facie evidence that the standards have been violated, I think that might be where they're leading to. But as it's written, a conviction means they've pled guilty or been found guilty, so the elements have been met. I'm not sure I understand completely the language there, though.
Okay, and let me go to Chief Audit Executive Davis. When you were working on this and this language was inserted, what was the intent of the language?
I think overall, as we were looking at the standards and the rebuttable presumptions, conviction is used, and in, dare I say, legal space, especially when I'm not a lawyer. It, just trying to understand, okay, conviction is used throughout the standards or the rebuttable presumptions. What does that mean? Should it be defined? If it's understood, maybe a definition isn't needed, but if we were to define it, okay, here we go. And I believe I did talk to my team about this. I do have an individual that he is not a lawyer for the board, but he's my outline specialist, and he is in there. So I believe I had talked with him, and so in coming up with it, this is the language we came up with, but probably like Ben said, with regards to, well, I'm just going to stop there. I won't go there. Just, yes, we were trying to define conviction because it is used and it could be unclear.
Yeah, a conviction is prima facie evidence. If there's a conviction, you have met all the elements necessary for that particular crime. So I'm not sure what that gets us. Okay, thank you for your patience, committee. Any other questions? Yes, Vice Chair Bollinger.
Thank you. Yeah, I have a list too, so bear with me, but I'll try to go through them quickly. But if I may, Chair, direct a question to Director Rasmussen. Director Rasmussen, so you've kind of mentioned that this would change some, or it would increase the reports. The way that this is currently written with the standards in the same rule, would then an LEA have to report an educator to UPAC for every violation that is consistent in the, or from any of these standards that are written in this rule?
Yes, let me just show the committee the language. So on, if you, this isn't, the reporting requirements are in what would be R277217. And so lines 210 through 216 there, an LEA shall report to the executive secretary within 48 hours of the completion of a judicial or administrative proceeding or internal or LEA investigation. If an educator is determined pursuant to the judicial or administrative proceeding or internal LEA investigation to have violated the educator standards described in 210 or the effective educator standards or those other references. So anything that's listed in this updated 210 would then be reportable to UPAC under these changes as proposed.
Okay, thank you. And if I may follow up, and Director Rasmussen, when we talk about whether this is an overhaul of the current practices in UPAC, can you speak to that? Is this just minor changes and clarifying practices, or would this entail a complete overhaul of how UPAC is currently functioning?
This would have significant impact on UPAC, primarily because of the reporting that we've just talked about, in that it's opening up a whole new space of this effective educator area as to be UPACable, as we kind of call it in our section. This would lead to a whole number of other things that LEAs would be required to report on teacher effectiveness that we don't currently handle. I think it would also impact our use of the expedited hearing process too, because, for example, DUIs and shoplifting charges, which we currently handle through the expedited hearing process, a number of misdemeanors become reprimands here. We'd have to expand the expedited hearing process to incorporate reprimands, which their rule changes to propose to do, but that would also lead to potentially additional hearings for those charges, because you can't just have an expedited hearing if there's a reprimand. The educator would be entitled to a full hearing, and it could potentially lead to a lot of extra administrative work to carry out a lot of these proposed presumptions.
And when you say it's extra administrative work, does that mean that you would need additional FTE in addition to the FTE?
I believe we would need additional FTE for this, yes.
And how would that impact LEAs? Would they also need additional FTE to handle tracking of this?
LEAs would have to be reporting a large number of issues with their educators that they don't currently report. I would expect that they would need additional resources to accomplish that. Yes, I can't, I haven't worked in a LEA HR department, but I think it would require additional staffing to do.
Thank
Vice Chair Bollinger, what line were you focused on with that?
That wasn't on a specific line. That was just in general.
With the, okay,
Yeah.
thank you.
But may I continue? On line 702, I gotta scroll down, hold on. It lists may not engage in immoral, unethical, or unprofessional contact or communication of any method. I know the word immoral is used several times throughout this document. I'm on line 702. And it is, again, it's listed several times. The word immoral is used several times throughout this, but I don't see a definition. And I've had several constituents reach out concerned about the use of that word without a definition. They feel like that's very subjective because what might be immoral to them might not be immoral to another. I'm just wondering if there was a specific definition or the use of that word, if you can speak to that.
Are you asking?
Sorry, if I may, to Member Bogus, through the chair. Thank you.
I thank you. So this word likely, through my conversations, especially in the past few days, early on teachers did not, when the teachers I consulted didn't have a problem with this word. But one of the examples was in particularly coffee. Like, and I'm a coffee drinker myself. Like I said, you do this and you become very self-reflective, right? You know, could you be reported for drinking coffee? And obviously, that, on its face, that's absurd, but technically, it could happen. I do believe the best way to remedy that is for us to define immoral, because it does lead in that space. It's not the intention, but we're thinking more in the space of grooming inappropriate long-term relationships, sexual comments, implied profanity in that space, those types of things. And so we're not thinking things like coffee. We're not thinking things like headdress or necklaces or anything like that. No, I don't know if that's what you wanted to hear, but the intention was not to get into the weeds, but to make certain that we had broadly covered some of the pretty just not good things that have happened through the years.
Okay, thank you. I appreciate that. And another concern on line 832 mentions violates a requirement or procedure in an individual education plan or 504 plan. And coming from the special ed world and being involved in several audits, I've never seen one audit ever come out 100%. And so my concern with this language is there are a lot of unintended mistakes that happen with IEP or 504 paperwork. And so my question, if I may, to Director Rasmussen, this would, if somebody made a mistake on an IEP, or even let's say that the special ed department was doing their audits, would those all have to come then to UPAC if they were violating those procedures?
So this is the presumptions part of the rule. I'm not sure what the corresponding provisions in the standards section of the rule would be, but I think that a lot of those would be covered under the effectiveness provisions and that. So I would suspect that they would have to be reported. I don't know if CAE Davis or would have any additional information on what specific language is included in the standards there. I didn't look for that one particularly. It has been something that we've started to see special ed cases reported to UPAC on a more frequent basis, much to the frustration of my commission members, though I would point out.
Okay, thank you. Also on line 836, and I know that this is also one that I've already talked to Member Bogus about, where it said violates a standardized testing protocol, because I've seen in situations where I've had a teacher forget to read the paragraph before a standardized protocol. And I know that that was not the intention of this. It was more of the
Taking pictures of the screen,
Yeah.
taking the test for students, some of the big ones, but I understand that technically is a violation. We're not after that in
Okay,
any way, shape, or
just
form.
wanted to clarify. If I may go to line 567. Yes. And this is under the teacher standards. It says, shall meet the learning needs of each student. And I know that as educators, we're always striving to meet the needs of a student. When it says shall meet the learning needs of each student, does this mean that if a teacher doesn't get the student to read on grade level, or if a child is gifted and the parent thinks their needs aren't being met, that then they can be reported to UPAC? Director Rasmussen, would that fall under that?
I think it's very broad, and it would be up to the interpretation of the LEA or parents, I guess, if they chose to file a report. But it is very broad.
Okay. If I may go to a few of the definitions, I've had a few people reach out about those. So if we can go to line 486, and I apologize, on this one I'm going to jump around a little bit because I want to talk about the definition and then see how it's used in context. So on line 486, the word timely is defined means as soon as possible, but no later than 2 working days. And I know that's always a standard we try to. I know we've kind of talked about responding to emails as soon as possible. But then when we look at how it's used in context, so on 568 and 570, now we're saying shall keep records for which the educator is responsible in accordance with law and policies in a timely manner, and shall communicate accurately and in a timely manner. So is the intent there that they keep their records within 2 days, and they have to do all their emails, like they can be reported to UPAC if they haven't responded to emails or phone calls within 2 days? Was that the intent, Member Bogus?
No, that's not the intent. So the intent is, for example, as a specialist, people will come and they will say, well, this is supposed to be happening, but the IEP has not been updated. And I have had no notification of that update. And so as we experience things in our schools, and then there are, as you know, many educators interface with students in a day. And for example, and I say this as because you brought up IEPs. So if the IEP has not been updated or communicated, but I'm still held accountable for its provisions, and so that is really, I think, the goal is situations like that in 568 and 569, is that those things need to be disseminated, because once it's been adopted, I'm accountable whether or not I know about it. And so that needs to be done in a timely manner. With regard to line 570, one of the number one complaints that I get as a board member, despite, I have a cluster in my district that comes all out of a general geographic area, and that teachers just don't respond to parents. They're like, how do I get my teacher to respond? And it's one of the number one frustrations, is that they feel ignored. They text, they go through Dojo, they use whatever the district system is, and there's just no response. And I would guess in that situation in line 570, perhaps that's a board policy decision. But I do think 2 working days is enough to flesh that out. And please don't get me wrong. Like I said, you really have a lot of self-reflection when you say things like this. But I do think, in interacting with your superior, 48 hours, 2 working days is good to respond to your boss, and vice versa. So if you were my administrator and I asked you a question, I think 2 working days that you're in the building, obviously not days that you're absent, right? But I think that that's a professional standard. Do I think everything like that needs to be reported to UPAC? No, I think that's stupid. But I would argue that if you have teachers who are chronically negligent, we have to have a standard to adjudicate it by. And so maybe we enhance the language to reflect that. I don't want to hear about every teacher who doesn't respond to an email, and neither do you. No, but I think we could make language and create language that would encompass that, so that it's more fair and sporting and better articulated. Thank you for the question.
And maybe this next one goes to C.A. Davis on line 544. It defines the word waste. And it says means to expend government funds carelessly, extravagantly, without adequate purpose, or unnecessarily, including expenditures made unnecessarily due to inefficient or ineffective practices, systems, or controls. I have my own feelings about certain things that I feel like are ways. Who determines this? How would this be, the way that this is defined, who would determine if it was inefficient or ineffective? What would that look like in a internal controls?
So through the chair, if that's okay. So waste, and I believe this definition actually comes from the Government Accountability Office. But I think it would be if someone submitted an allegation, there would be an investigation. So as part of that investigation, you would go back and use the criteria to say, okay, what did it look like? So that would be my assumption.
I'm almost to the end, you guys. Thanks for bearing with me. If I can go to line 156. And this looks like this is part of an extended definition, if I'm reading it correctly, of boundary violations. And on line 156, it talks about, and it's basically saying that educators shall not do these things. Photographing or recording a student for non-academic purposes, including marketing, publicity, commercial use, and it goes on. So I've had a few teachers reach out, a little concerned because they oftentimes, when they're trying to get kids to participate in their, let's say their classes, or even I've seen this with districts, even on like a district strategic plan where they do have pictures of students, and of course with parent permission on those as part of marketing. And so Director Asmussen, on this piece, would that preclude educators from that practice?
Trying to remember what the initial language was at the start of that section. We have some similar language in the current rule on photographing students, but it's made clear that it's fact dependent. But this says that yeah, but so those are things that are included as boundary violations. I don't know that it so this isn't I don't see the discretion written into this one as much as it is into the current rule. So I would say that would be a boundary violation under this rule, yes.
Thank you. I appreciate it. I have a few more, but I'm at this point, I just I agree with Member Bogus that we want to have a high standard for our educators. And I absolutely feel like we can continue to improve on that. I think it's an ongoing thing. We continue to have high standards and hold them to it. And so I appreciate the intention behind a lot of this. I appreciate the work and the time. I'm concerned the way that this current 210 draft 3 is written, where I'm not comfortable with the standards being absorbed into this, just because of the impact it's going to have on UPAC, the number of increases of referrals for things that I think could and should be taken care of at an LEA level. Absolutely, there are things that we want to make sure we're helping our teachers with, but I work with a lot of brand new teachers, and there's a lot of times it's just because they don't know. There's just so many things to know, and so I'm just concerned with the way this is currently written. So at this point, the way that this draft is written, it's not something that I can support.
Vice Chair Bollinger, let me ask you, when you say the standards being incorporated, what are you referencing or referring to with that?
So from my understanding, and Member Bogus, you can correct me if I'm wrong, we've taken 217, which is listed out kind of the educator standards and expectations, right, and put them into this rule. But because they're under this UPAC, as Director Rasmussen was mentioning, that then if there's violations of any of these things, then they would have to be reported to UPAC.
But can I add to that? I think there's another related piece.
And you can. I'm just trying to better understand like the influx
And I
of
was-
cases, and that's what you want. Okay,
Yes.
sorry. Go ahead, board member there.
And I think the standards that, Matt, and I don't want to put words in your mouth or in your thoughts, but there is another set of educator standards that are effectiveness standards, and they're in a separate rule. I believe it's R277-330. So there are those educator standards that are about effectiveness and teaching strategies and that kind of thing, that was sort of my point earlier also, that they are being conflated with these standards of conduct.
But when I asked where, like, can someone show me where that?
R277-330.
Well, that's where they are, but how are they being incorporated here?
I've
Like
got
that?
A laundry list now.
Okay, well, I'm just saying because I know that was the very first issue that was raised. It was the first question I asked, and nobody could point me where that was happening.
Only because some of us hadn't made that list, but I can give you a list of lines if you want to just write these down and check them out, because
Sure.
there are many places. Line 556, and there's no particular order. Line 556, line 618, re-administrators, about administrators, line 621 through 622, line 246 that references the rule I just mentioned, 330, and specifically makes it, these are all, and they're not all exactly boundary violations. 246, line 662, line 669, line 697, line 564, and those, I'm sure that's not exhaustive. It's just things I've received from other people and have found myself. Those are where they're combined, and which brings me to another point, if I can just quickly make it. I think both Chief Executive Officer Davis and Member Bogus have mentioned that they looked at other states' standards. And if there's a spreadsheet that you created because of that, that would be super helpful for all of us. But I'm not no buts. I am concerned that it's not been Utah's practice in the past to use these both together, to use them simultaneously as standards that have a penalty that could cause license discipline, even if not revocation, it could cause license discipline. So I'm just interested in how those work in other states, and if there's a spreadsheet that shows that, or you can give us information about that for research you've done, that would be helpful. And I'm not giving you a to-do list, I'm just saying that would be helpful.
Would you like me to answer that?
Let me do this if I may, because I want to make sure that I understand what's happening, because, and I appreciate Board Member Lear tracking down those references. But again, Director Rasmussen, let me, if I could, go to you first. Line 239 says educator misconduct means, and then line 245 and 246 says conduct that violates standards established in the UPAC Rule 210 and Rule 277-330, which is our teacher effectiveness standards as I understand it. The way this is currently constructed, or if this rule were to pass, are we now saying that if there's an accusation that an educator is not effective in the classroom, would that become a UPAC issue that could affect someone's license?
Yes, by the plain language of R277-217. If you look on 210 through 221, that requires reports of all the educator standards and anything under the effectiveness, those two sections of the effective educator standards.
Okay.
To come to UPAC.
Then let me go to Chief Audit Executive Davis. When this language was inserted into this proposal, was it the intention to have violations of R277-330 trigger licensure issues for the educator?
So maybe a couple things with that. So R277-330 is a board rule, which would then have the force and effect of law, and 217 requires educators to comply with federal, state, and local laws. In R277-330, there is a provision under it has professional responsibility that refers back already to R277-217. So it says demonstrating an awareness of and an adherence to professional and ethical standards within their school and with families and communities as required in R277-217, the educator standards and LEA reporting. So there is kind of this intent of, oh, there's standards in multiple places and who knows what standards we're talking about. And so what do we mean by standards? So yes, currently it's incorporated in 210. Could there be an amendment to just say like, hey, let's just take everything 330 related out? Sure, absolutely. But that doesn't remove the obligation that's already in our 277 330 related to 217.
And is it your understanding that the way the language is currently written, that everything in 330 should be treated as a potential, or could be treated as a potential UPAC violation? Is that the way you're reading the language? That's what it sounded like you were saying.
Based on the line that was just read, whichever the line was in 200, I think that's what it says, but there are some specific things that are pulled out in standards, whether or not that needs to happen or not. Again, board policy decisions, so.
Okay. And Board Member Bogus.
Yeah, that tautological relationship already exists between these two rules. So if the board as a policy position wants to sever that, so it may not be happening, but the way the rules are written, it could be happening and it would be perfectly legal to do so. I think we're kind of taking light of it, like we're drawing our attention to it because we've overtly expressed it here, but that relationship, as Member Bollinger expressed it, already exists. And so it's being called out here. And if the board wants to sever that relationship between those two, then that would be a policy position. But 330 is already state, local, and whatever law. It has the force of law. And one of the standards is to comply with all the laws. So if we're going to sever that, we need to rethink how we're doing those standards and how we frame that. Because that tautological relationship between the teacher standards and the effective teaching standards already exists.
Director Rasmussen, that sounds, so for instance, jaywalking is against the law, right? But we don't.
We accept minor traffic offenses from what needs to be reported to UPAC.
Okay. So is your understanding of 210 and 330 and 217 such that you agree with the explanation that was just provided, that the teacher effective standards are already incorporated as UPAC violations? We just haven't been doing it. Do you agree with that analysis?
No, I don't know that I do necessarily agree with that. I mean, we do have the provision that you have to follow the law, but we don't have any LEA that's ever reported anyone to UPAC that I can think of for violation of the effectiveness standards. I mean, we have, how many, 300 rules? I don't think we have an expectation that every time an educator violates one of those rules that would be reported to UPAC. So I don't know that I would take it that far, no.
Can I speak to that too?
Yes, please.
I think that it is important to note that in 330, 217 is referenced, but 217 as it exists doesn't reference 330. And there are no penalties built into 330. So for better or worse, it's more of an aspirational rule that is then used by employers to help teachers improve. So I don't believe that it's a circular tautology, if that's not a contradiction in terms or a duplication. It's not, because 330 is a different kind of rule without penalties, as opposed to now you would be introducing 330 to have the penalties that misconduct has. And I think that is a pretty dramatic change, especially when we've listed at least 15 to 20 times when those kinds of effectiveness standards are now introduced as boundary violations for the most part. Not all of them are in that section, but a lot of them are.
And so let me ask again, is it your desire, Member Bogus, to make those violations of 330 UPAC violations more explicit? Is that your desire with this language? Or was this
In which line?
in the lines that we just covered, right? As Director Rasmussen said, the plain language is that under your proposal, violations of teacher effectiveness standards would now potentially constitute violations of our UPAC standards. Is that the desire of your proposal?
So I'm going to reframe your question, if that's okay. If a minimally effective teacher should be reported to UPAC, no. But a chronically negligent teacher should be reported to UPAC. And that I think maybe we have to reconcile as we're having this conversation, because a minimally effective teacher can be remediated. A chronically negligent and ineffective teacher, that needs to be adjudicated, because it's educational malpractice and professional negligence at that point. And we can't raise the bar in the system if we know that teachers are losing their jobs, but it doesn't affect their license, and performance issues are an LEA decision. But there has to be a way that these individuals don't hop from school to school, because it perpetuates the chaos that this institution mitigates. And then this institution, there's no flag on the license that said, hey, there were chronic issues here. There's no flag on the license. And then this individual gets hired over here. The chaos ensues over here. And it muddles our system. And other states have found a way to reconcile that. I don't know that this is the best way, but I think there is a way. But I have no desire to have end of the year evaluations all come up and then we have a bunch of UPAC things. That absolutely not.
Okay. Thank you. Any other questions from the committee?
More comments that will be equally, this, my last one was brief.
Yes.
I asked for the spreadsheet, and I'm serious about that. If there is such a spreadsheet, you didn't create one. It didn't just, yes or no is good enough.
I don't believe so with the state standards. To the best of my recollection, I had a pile of paper and I just started color coding. I don't think I ever made anything digital.
Okay. Secondly, I thought that expedited hearings were crossed out in one place. I didn't find where they were put in again. Are you doing away with expedited hearings?
No.
Okay. And then thirdly, I've heard you say many times, and tell me if I've misheard, we're not thinking that. No, that wasn't what we were thinking. Even in your just brief discussion previously, it was like, no, we didn't intend minimal effectiveness problems to become UPAC issues. And yet I'm concerned that those words are under boundary violations now. Those phrases, those words, as we've said repeatedly, plain language are under boundary violations. And I'm concerned that not only, and tell me if I'm misinterpreting when I finish my sentence, but I'm concerned that they not only then the plain language would reflect UPAC reports and cause the problems we've talked about, but I feel like they're also an intimidation factor to teachers. I had one email that said, does this person hate teachers? And you'd be pleased to know, in your defense, I wrote back and said, this person is a teacher. But I feel like that was the message that some people got in reading these revised rules. So that was another comment I wanted to make, that I think we have to think about not only what does this communicate to teachers as boundary violations, which then prompt penalties, as opposed to other rules that are, this is what LEAs should do in order to develop effective teachers. Those are my comments.
I just have just one other, and this builds off of Board Member Lear, on line 858 and 859, and I want to make sure I'm understanding this correctly. It says a suspension of 2 to 5 years is presumed appropriate for serious violations of the educator standards, or if an educator. And I'm confused by that duality of terms, but that's not my issue. So a 2 to 5 year suspension of license is presumed, and then if you go to 879, if they engage in a boundary violation. So Director Rasmussen, again, I go to you as, if this rule were to pass, is this to be read alone or in conjunction with the surrounding text? Like, is a boundary violation, for example, the use of profanity is a boundary violation. under this rule, would that result in a presumption of a 2 to 5 year suspension of license?
An individual boundary violation, as I read that, would result in that suspension, yes.
So the singular use of profanity, under the way this rule is written, the presumption would be a 2 to 5 year loss of license.
I can't remember what specifically the boundary violation definition said about profanity, but I will accept your representation that it's in there. And
Well, let's go to 131. Okay, it might be 149.
149. So yes, that does appear that it would lead to a suspension.
Well, I'm glad this is here. And would the telling of an unprofessional joke under this proposal lead to a presumption of a 2 to, was it 5?
2 to 5 year.
2 to 5 year suspension of a license.
As I read it currently, yes.
Then the other question I have is if we go back, and again, I apologize for all the back and forth, but if we go back to 879, so it says if you engage in a boundary violation, the presumption is 2 to 5 years. Unprofessional joke and use of profanity. Yes.
Can I? I would point out one other thing that this does allow the use of aggravating and mitigating factors.
I understand.
And that could reduce it down to, I think, a 1 year suspension, but it only allows it to go down by 1 degree.
Okay.
But there's also no clarification that it's off campus or off work time. So profanity, dirty joke, off school time would also be the 2 to 5 years? No. And where's that
Please,
Can I?
please.
cleaned up? Because I read it that way.
So that's why those spaces are in there, inside the school, in engaging with a parent, in engaging with your peers, and engaging with the public. Now, if you want to go to a bar on a Friday night with your friends and do your thing, whatever, dude. But in your professional capacity, and so if there's missing language that needs to clarify that, but in your professional capacity
says-
is the general theme of all of
It's
these.
just under boundary violations, period.
Okay, and so then, if we need amendments, then we need to amend. But I think that, there might be either, like, we might have gotten it in the wrong spot, but,
It
boundary
wasn't
vi-
the intent.
No, it's not the intent to suspend people for swearing. Now, if they go on a tirade and freak out, I think that would be different, but no.
And let me just circle back. So we have boundary violation. I mean, beyond excessive, in my opinion, the way it's written. But then I'm also concerned that the use of profanity has the same presumption as engages in consensual sexual activity on school grounds, knowingly engages in sexually explicit conduct with a recent graduate. So I'm looking at the proportionality, but that's my interpretation. Director Rasmussen, I'm going to direct this question to you. And again, starting at line 879, well, actually, it starts in line 858 to 859. A suspension of 2 to 5 years is presumed appropriate for serious violations of the educator standards, or if an educator. And then it goes to 879, engages in a boundary violation. And then on 883 and 885, it talks about the consensual sexual activity and engages in sexually explicit conduct. If this rule were to pass, it's the way I read it, it's that a boundary violation, irrespective of the type, would be treated to that same presumption as would engages in consensual sexual activity on school grounds.
Can I interrupt there just a second?
Yes.
So, Board Member Bogus recommended that we bring this language in because of the committee's actions on 217 in the drafts that are currently before the board. I kind of pigeonholed that there based on my best guess, but I don't think you would attribute that to their proposal. I just kind of thought that's about where it would go, and that's where I stuck it. But that could be something that could easily be moved if it needed to be in a different place.
But the way where you inserted it, it's leading to the same presumption, right?
That would be the presumption, close to the presumption it would be now.
Okay.
With the other proposal pending.
Understood. So the use of profanity under this proposal would have the same presumption as engages in consensual sexual activity on school grounds, knowingly engages in sexually explicit conduct with a recent graduate, the way this rule is currently constituted.
The way it's drafted, yes.
Thank you. CEA Davis.
If I add a little bit more clarity, and because there were so many different things with this rules moving different directions. So I did, going back to earlier drafts, the way the language was proposed was still in the 2 to 5 years, but it was engages in a boundary violation of bullying, cyberbullying, hazing, retaliation, or abusive conduct. So those specific items, it looks like were not included in the final draft. So as currently constituted, everything you said is accurate. In the initial version or rough draft, it did have some specifying language, so it would not be specific to everything that's included in the definition of boundary violation, but that's just some context, but could go either way, depending on how the board wants to make changes, if they want to make changes.
Okay, so the draft 3 does not include that language from the earlier draft that was intended to be carried over. Is that okay? Thank you. That helps. Okay. Any other questions? Comments? If not, we'll entertain a motion. Yes, Board Member Longacre.
Okay, excuse me, I'm still new and that's my excuse. So I motion that the committee approve R277-210, draft 3 on the first reading and forward it to the board approval and second and final reading. Or no, is this the one that I'm reading? Okay, the committee, yeah, that's the one that I just read. That the committee approve R277-210, draft 3 on the first reading and forward to the board for approval and second and final reading.
So I'm going to speak against the motion. I understand from the remarks that were made that I agree with the intent, but I think what's become clear is that the language that was used and things that were omitted or placed in the wrong part, I don't think the intent comes through with the actual language of the rule. And unfortunately, it's not unfortunately, but it's the language of the rule that we have to apply. And the way this is written, a presumption of 2 to 5 years for the use of profanity, to me, extremely excessive, possibly unconstitutional. The telling of an unprofessional joke with that same boundary violation, I just have deep concerns about that. Having said that, I think there are several good elements, and that's the nature of the committee hearing, right? We focus on the things that we are concerned about, not the things that we agree with. But there are several good parts to the rule, but as it's currently framed, the language that it currently uses, and I credit Member Bogus for acknowledging that, look, there are things that need to be changed. Just given the magnitude of those things, I could not support passing this along to the full board at this time with a positive recommendation, and that's why I'll be voting against it at this time. Vice Chair, Board Member Hall.
No, I just want to say, I think there's a lot of good things that are here, and I really appreciate the hard work and the effort and the time that was put into this, and I hope that you'll go back and make all those changes, and I'm looking forward to seeing what comes back in the finished product. So, no, I'm sorry.
Vice Chair Bollinger.
Thank you, Chair. And I would agree with what Chair Carey has said. Member Bogus, I think the intent of what you are hoping to accomplish, I can support, and having a high expectations for teachers. I'm concerned that, and I think that maybe there's well, let me rephrase this. When I hear from Director Rasmussen that it's a complete overhaul, that it will increase FTE needs both at a USBE level and an LEA level, if that is the case, then I have a hard time passing something that I feel like should include more stakeholders. I do appreciate your long work. I appreciate your engagement with so many stakeholders and your responsiveness to that. And I think that that's great. When I hear that the last time that the UPAC rules were revised, it was a whole group and committee, I have a hard time pushing something through that's going to make, as Director Rasmussen said, an overhaul of our UPAC without that type of a process. So at this time, I won't be able to support this as well.
You said something, Vice Chair Bollinger, that made me think of something I think Deputy Newey said. Are these UPAC rules up for their 5-year renewal at this time?
February, they're due for 5-year review.
I mean, this is kind of like Vice Chair Bollinger's proposal about creating a new license. So let me think before I articulate this.
I'll speak what I think.
Please.
I share the concerns of Chair Carey, Vice Chair Bollinger. I also would like to get a copy of that the court mediated agreement from 2016, and see, just to confirm for myself what I think if there are any remaining constraints, or if there's anything that the court suggests as still significant 9 years later. So I really would like to put that into the mix. And I would like to also make sure if it's less formal than what happened 9 years ago, or less ongoing, if we could have a broader range of stakeholders, especially those people, excuse me, who are the employment experts in LEAs, be able to weigh in on this, because I am very concerned about the employment, the overlap with employment in LEAs, because I very much do trust our LEAs. I think we have to. There aren't enough policemen to police 160 plus LEAs. So I think we have to trust them. I also have to add a third component that is a reason for my no vote, and that is because I think a lot of this is about training. Perhaps our money should go to supporting more training for teachers than, and use the carrot rather than the stick, or at least try that in advance. And I know that would involve more personnel as well, but I would rather have excellent, robust, strong training before we impose more draconian consequences.
Do you want me to respond to that?
That's just about my vote.
You don't.
So,
Okay.
And again, I'm just going to put this, and I know we have a motion pending, and But if our UPAC rules are up for their 5-year renewal in February, and this is what I was conversing with Deputy Nui about, we would have to have the renewal. Well, Deputy Nui, let me just defer to you. Could you mind explaining with that process to the committee?
Sure. So the Office of Administrative Rules requires that this board review every single one of their rules, your rules, on a 5-year rolling basis. And so if it doesn't get continued, then it automatically gets sunset from OAR. We usually don't have a lot of rules that come just for continuation because this board sees, we update the rules for legislation or for board member preference or staff recommendation anyway. So that's an ongoing process that you see all of the time. What that means though is that if it's going to expire in February of 2026, it needs to be to OAR by February of 2026. What that means for this board is that it would have to be at the January board meeting and the December committee meeting in order to meet that timeline. If this committee were to put together a working group, that means that that working group would have to be formed and have their work done by backup deadline for December board meeting, which is a tight turnaround. So what we could do is these rules are on the full board agenda in a different capacity for later today. If this board passes those, we can continue them at the same time. Through that process, there is a provision in your bylaws that allows us to do a continuation at that same time. And then this committee could put together a working group and they would have, if they wanted, a full another 5 years until it needs to come up according to OAR law, if that makes sense.
So let me say this. I think that our rules do need to be reexamined. I don't think that's a secret. I think that we have deficiencies in them that are structural in nature. I don't want to see the work put into this rule go to, I want to build on the work that's been done. But I will ask the committee what their thoughts are, and then, well, let me find out, what is the committee inclined to do?
I like Deputy Nui's proposal, giving us more time. I've said to you several times, we have a brand new superintendent. We've got other very, very immediate issues that are crucial for the board to deal with. We've got a legislative session coming upon us. I don't think we could do justice to the work that's been done and some of the changes that all of us have expressed we would like to consider in a month and a half, essentially, to be ready for early December. So I feel like we should, and I don't disagree that after 10 years there are some changes that are probably in order, but I feel like I would like to give us time to do it well and thoughtfully, involving important people. So I'd like to do what I keep telling you representative, so sorry, what Elisa's suggesting. I think is a really good suggestion to give us time to do this right. And that would still allow us to build on the work that Christina has done, and maybe her stakeholders could talk to our stakeholders, and we could have a joint discussion.
Vice Chair Bollinger?
Thank you, Chair. I also agree with Member Lear. I think for us to do this justice, this is a big lift, and this impacts a lot of teachers and it impacts a lot of LEAs, and we have to get it right. Obviously there's always things that we are fixing and improving in our rules, as Deputy Nui had mentioned. However, I'm concerned if we try to rush this through. In addition, when we talk about a working group, I'm not opposed to that, but I do think that we need the correct amount of time to do that, and I think we need the right stakeholders. I think it has to include a variety of stakeholders so we can make sure that we get all viewpoints. I think we just build better policy and rules when we involve more voices for the people that are actually in the schools, seeing these things in action and how they play down into the schools.
So I'm going to ask Board Member Longacre, this was your motion, so you wanted to move it forward. I will say it happened before I started thinking about the renewal period, but I would like your thoughts on how you would like to proceed, if you're willing to share those with the committee.
No, yeah, and just be patient with me for a second. So we do agree that there needs to be some amendments and just this draft would need to be updated or fixed, correct? So how do we do that in a timely manner? I do feel like we do need to raise the bar a little bit, better sooner than later, but the right process, how does that look like? I don't know. Do we give Member Bogus the opportunity to make amendments and then issue this again to our committee? I don't know what the process is or how that works, but we all agree that there are some amazing things in this. Some things need to be fixed. How do we do it sooner than later?
That's a great question. I would just point out that, remember, there's 3 more proposed rules that are part of this particular submission, right? We've addressed 1. So regardless of what happens to this motion, there's still 3 other aspects of this that we could look at and that we would need to look at if we wanted to afford Member Bogus the time to amend and address some of the concerns of the committee. So, we'll vote on this, and then we'll entertain a motion on the next step. And I think that recognizes the motion that's on the floor. So the motion on the floor from Member Longacre is that the committee approve R277-210 Draft 3 on first reading and forward to the board for approval on second and final reading. All those in favor?
Aye.
Those opposed? And we'll just take a voice vote. Member Lear, Vice Chair Bollinger is a no. Member Hall's a no. I am a no. That motion fails 4-1. Does the committee, would anyone on the committee like to make another motion? Board Member Lear?
I don't know that we can make a motion to prospectively say we will
I understand.
continue. But I would like to eventually, without setting a finite period, like to put together a working group and have a more complete discussion with others who would have a stake in the important stakes in the changes that are bringing about. And it might be appropriate to have all 4 rules discussed or related rules discussed. Maybe 330 should be discussed with these. I'm not sure. But I would like to have that come about in the future, but I'm not prepared to put a timeline on a long motion. So my motion would be that we convey the information that this committee has discussed and maybe more in person from the chair and the vice chair than only in the minutes to the leadership of our board and let the board know that we'd like a working group to further discuss the rules that Christina has worked on very hard and for a long time, and then bring a working group together to discuss those further in the future. You can cut out half of that, whoever's writing.
So the motion before the board is that the committee share the committee discussion with the board and recommend establishment of a working group to review UPAC rules.
And I actually said board leadership, and I think that would be the decision. That would be the decision maker for a working group.
So the motion before the committee is that the committee share the committee discussion with board leadership. Can we delete the with board leadership? And recommend establishment of a working group to review UPAC rules.
I thought it was sufficient that Chair Carey and Vice Chair Bollinger have a more personal discussion with board leadership, so they if that's a mutually agreeable thing. I don't want to force you into discussing stuff, but I thought it was important that board leadership hear the committee's concerns and also Member Bogus's responses and intentions, because there were a lot of those.
Okay.
So may I just very quickly? People keep saying Member Bogus. Chair Hymas consulted on this. Superintendent Hart consulted on this. I get the credit because I'm sitting in this chair, but these were not all my ideas. This was a collective response from multiple members of this board and from multiple members of the education community. And so while I appreciate you giving me credit for all of this, there are some of these things that I was actually hoping you would amend out, but they were included in an effort to be encompassing of other people's ideas. And so while I appreciate you continuing to give me credit, there were many, many members of this board that consulted on this project. So I just want to make that very
We can
clear.
just call it draft 3, and then it doesn't.
That's fine with me.
Thank you,
doesn't
Member
belong to
Bogus, for sharing that. And
Thanks, Doc.
I think we're recognizing the effort because, and I'm glad that the timing worked out the way it did. And I'm happy to work with Vice Chair Bollinger. We can talk to leadership. In the end, it'll be their decision, and probably Matt may even just take it to the board for a vote. Let's vote on this, and then there is one item that still needs to be addressed, and that is, remember this, well, let's vote on this first. The motion before the committee, that the committee share the committee discussion with board leadership and recommend establishment of a working group to review UPAC rules. All in favor?
Aye.
Any opposed? That motion passes unanimously. This is my question. We still have 4 other items associated with this item number. And even though, and this is my understanding, even though this committee may not send something forward with a positive recommendation, the board can still hear it if the chair pulls it. That's my understanding. And because of that, I think we have a duty to examine and go through the remaining related items, because in October, the board still could have the opportunity to look at and want to know what this committee thought of the proposal in terms of, was it a positive send out or a not recommend send out. So with that, I just want to put the committee on notice that I'm going to ask Vanessa to schedule a time for us to meet as a committee to discuss these items. Board Member Lear.
I was just going to say, I would prefer that it is the Law and Licensing Committee that meets to discuss these because they're Member Bogus's, though not her own, not her solely, let me put it that way. I would prefer that it was just the committee and Member Bogus discussing these as we go. If that, maybe that's an amendment to your motion, or you were thinking that. Probably should have posed that as a question.
Yep. Well, let's do this, if this is okay. I don't think we need a motion. I think that under our rules, I can call a meeting. So let's work on finding a date, if that is okay, and it will be within the next, I would hope, 10 days, 14 days. I'd like to do it sooner rather than later. Again, work through the rules, because we are expected to have a recommendation should the board want to hear it. Okay?
Yep. Chair, I was just going to say, and I should have said this before we made our motion, but I really do hope that we'll keep Member Bogus at the forefront of this. She's put in, a year into this and a lot of hard work, and hope that she'll be still leading the charge as we move forward in this process. And I just don't like to leave it open-ended. I'm glad that you've given it a timeline that we can move forward, and I hope that we'll continue to do that until we come up with a finished product.
Okay. We'll take one final motion. Okay. All those in favor? Oh. Yes, we did. It's just the only last one is just the date and time for our next meeting. Right, because we can't vote on this one. Yeah. Thank you.